segment முடியும்போது ஸ்டாப் கொடுக்கணும் இல்லையா?
ஸ்டாப்லாம் கொடுக்கணும் அவசியம் இல்லை. ஈவெண்ட்டை எண்ட் பண்ணாவே அது ஸ்டாப் ஆயிடும்.
ஓகே, நான் ரெக்கார்டிங் ஸ்டார்ட் பண்ணிட்டேன் ஆல்ரெடி. இப்பயே போட்டு வச்சிடுறேன்.
இப்பவே போடுறியா?
ஆமா, இப்பயே போட்டுறேன்.
சரி சரி
சரி சோஃபியா, பிரசன்டேஷன்ஸ் மட்டும் வாங்கி வச்சுக்கோ பேக்கப்க்கு.
சரி விஷ்ணு, ஓகே.
ஓகேயா?
சரிடா.
ஓகே, ஃபைன் ஃபைன் ஃபைன். தேங்க் யூ. தேங்க்ஸ் ஜேகே. குட் ஆஃப்டர்நூன் மிஸ்டர் சஞ்சய். Good afternoon, sir. Good afternoon, Mr. Sanjay. Can you hear me? Vishnu?
Hello, Vishnu, can you hear me? Vishnu, can you hear me?
I can hear you.
Mr. Sanjay is there. Mr. Sanjay.
Sanjay, can you hear?
I'll
Yeah.
Good afternoon, sir. Can you hear us?
Yes, I can hear you.
Okay, great, sir. So, would you like to switch on your video?
Yeah, that's exactly what I wanted to try.
Is there any video option?
No, I just want to share my file.
Okay, so what will I do now? I will change the role to presenter.
Yeah.
When you were, when you present during after the first session.
Okay.
So your role is now changed to presenter.
Okay, let me just try and then we can go from there.
Yeah, now you will be able to share the content, which is the third icon.
Yeah, 1 minute. Huh?
Yeah.
Okay. Is it visible?
It's visible, sir.
Yeah. So this is what I will do that. Okay, I'll also email this just in case if something happens.
Sure.
Okay. So right now.
Yeah, during your session there will be 3 people, right, sir? Who will be making.
Yeah. So they are also joining at about 1:45. I'll just message them. 1 minute. So what they will do is they will also have the same presentation with them. Okay. So after I've finished my part of slides, say until yeah. Yeah. So they will come on till 44 slides I will talk, and then after 45 they will pick it up, the same presentation they will share on their computer screen. So you'll have to, what I'm planning to do is after 44, just wait for 3 to 4 minutes as a Q&A, saying whatever I have given my presentation on this particular piece, if there are any questions by the audience and stuff, so that will give them some time for my other colleagues to put up this presentation on their computer screens and go on with that part. Yeah.
Okay.
Okay.
So what I understood is like after your 44th slide, you will be taking Q&A from the participants.
Correct.
And then your students.
Other colleagues, other colleagues will talk from 45 until
75.
75. Yeah. Oh, so yeah, my colleague is here. So he will take over then from 75 onwards, right until the end. And again at 74, we will just have a Q&A for that particular piece of presentation, which my colleague Parth will give. And then that is the way we will flow and end the presentation within the time period given to us.
So after 75, from fifth slide, you will be taking the control.
No, after 75, Amrish Satyanathan will take. Before that, Partha Sathi Jha will take. And until 44, I will take. So they also have this presentation on the screen, on the computer. So once what I will request is that while the Q&A is going on, after that, if you can make my colleague Parth as the presenter after 44, and after 74, Amrish Satyanathan as the presenter, so he will start with his slides.
So it's like 1 to 44 will be you, and from 45 to 74 it will be part of part. And from 75 to the end it will be started.
Sorry, Vishnupriya, I can't hear you. Can you?
One moment. Can you hear me now?
Yes, perfect.
So what I was telling is like 1 to 44 will be Mr. Sanjay.
Yes.
From 45 to 74, Mr. Parthasarathi.
Yes, ma'am.
And from 75 till the end, it will be Mr. Amrish.
Perfect.
So what will I do is after 44th slide, we'll be having a Q&A for Mr. Sanjay for 3 to 5 minutes. And then from 45 to 74, I'll change the role to presenter to you.
Okay.
To Mr. Parthasarathi. After that, 5 minutes will be a Q&A to Mr. Parthasarathi. And from 75 to till the end, I'll be changing the role to you as a presenter. You will be taking the questions at the end of the session.
Okay. Parth, are you audible? Are you clear with everybody?
Yeah, I can hear. Can you hear me?
Yes.
Yes, we can all hear you.
Yeah.
Okay.
I just also wanted to test something on my presentation because there are notes in the presentation. So I want to be able to see them when I present them. But I don't want, so there's a presenter mode in that. Can you just allow me to share content so I can test that?
Yeah, now I'll change the role to Mr. Ambarish as a presenter.
Yes. Then I will also do the same. Yeah.
Yeah, Mr. Ambarish, you have been changed.
Okay, so I'm about to. So as you can see here at the bottom of the screen, there are notes. The ideal situation is that when we go to presentation mode, you should not be able to see.
We are not able.
Okay, 1 second. But yeah, what can you see now? Can you see these notes?
Yeah. Yes, I can see. We can all see.
Oh, you can see the notes. So then this is not working that way.
Amrish, what you can do is, can I just suggest you? Do one thing, just go with the normal presentation. Just download this presentation on your iPad, on your email, and just keep it on the side.
Makes sense. I'll do that. That makes sense. I'll do it that way.
Yeah.
Okay. Perfect. So I'm going to unshare. That's the only thing I needed to test. Parth, you want to test something?
Yeah, I just want to once test the mode of presenting, because of course Cisco WebEx is first time I'm using. So can you leave it and I just need to click on this share content arrow?
Yeah, share content.
So should I do it? Can I do it now?
Yeah, you can click now. You have been changed as a presenter.
Okay, so let me just do that once so that I am able to do what I want to do. So that, okay, and then it goes here. Okay. Very good. Can you see this now?
Yes, we can see.
Yes.
And we can change it to full slides also, maybe, right?
Yeah. You'll have to do that to full slide.
Yeah, so I can change it to full slide. That's it. and that's fine. That's fine. Okay, good. This is working. Yeah.
Great. Okay. So, I'll just explain the question and answers. It will be a kind of chat, which will be participants will be posting the questions in the chat box. You
Yes.
can see the chat box, right? Once you
Yes.
click the icon, I'll just send a message. You'll be able to see the questions here. Have you got mine?
Not yet.
One moment.
In fact, I'm trying to type something in it and it's not letting me
No,
send also.
no, it is like you'll have to select the, from the two, you'll have to select the name of the panelist, or you can just select the presenter.
Oh, so so when I click on Q&A, I don't see anything. I just see all which has 0 in it. So maybe that's something only the viewers will be able to see. I don't know. I don't know how that works.
The
So
participant.
Yeah, even I can't.
I got the message from Mr. Parthasarathy.
I am
Okay. Even yeah.
I'm able to say hello to everyone. So
I
with
got.
yeah, basically this goes hello to everyone. So all parties who are participating, if I only want to say to Sanjay, I will say Sanjay and I say hello. Let's see if anybody is able to see. It might have only gone to Sanjay. Hello from me. Can you see that?
Yeah, we can see that. Yes.
Yeah, I can see that.
Okay.
Right.
But listen, there is a difference between a chat and there is a difference between
Q&A,
Q&A.
yes. That's what I was going to say. Yeah.
Yeah, so that we have to be mindful, because Q&A will be from the audience, where you will get your questions and be ready. As far as whatever you want to discuss between panelists, so that everyone button, you will change it to either
The
Vishnu Priya, attendees, panelists, Tulsi, everybody.
So,
Yeah.
ma'am, you will be taking questions, I assume, and you will be taking questions and putting them to the presenter. Is that, or is that the presenter himself has to read the question and reply?
all the panelists will be able to see the question.
Right.
So you can pick, you can select questions and you can answer it to them. You can just select the questions and you can answer it.
Understood. Understood. Okay. So basically, then we'll have to just see that within the limited period of 5 minutes or 6 minutes, whatever the Q&A will be, we just need to pick up one or two questions, the first
Yeah,
one or two, three questions in serial and respond to that.
definitely. Yeah, that is the order.
Yeah.
So
So maybe you can say the whole cadence of meeting you can set out at the beginning, and thereafter, if anyone has any questions, they can always reach out to us through email and all that kind of thing we can add that
you
time.
will share your email IDs to them. Yeah, we'll be sharing the presentation and the email IDs to them with your permission.
Sure,
And
sure,
they can post your questions through email. So whatever time we have now, they can post the questions for five minutes, and you can take it up.
sure. Great.
That's clear. Okay, fine.
Okay, so we are all ready.
Thank you.
Okay. Yeah, just mail us the presentation alone.
Oh yeah. I'll just do that right now.
Thank
Sure.
you. Thank you.
So it starts at 3, right?
Start
No.
two. I mean, there is a previous presentation.
So I'll come in,
No,
sir. My name is Tulsi Raj. Vishnu, sorry, I'll button. Sorry. So the first session with Dr. James is between 2 to 3:20. So if you could log in by around 3:10, that will be all right, please, sir.
Okay, we'll do that. Hello? Yeah, are you there? Hello?
Yeah.
Yeah, so I said that we can log around 3:10, right? That's okay with you, right?
Yeah.
Okay.
yeah, you
Yeah,
can
but
log in.
if we want to log in a little earlier, just so we can inform our content with James's content, it's okay if we log in earlier also, right? There's no objection.
Yeah. Absolutely.
Yeah.
Yeah. So Amrit, that's great. I have a call at 2, so I'll also try to come in as quickly as possible. Okay.
Right. Done. Okay.
Okay.
Thank you.
Thank you.
சொல்லு விஷ்ணு.
ஹலோ
ஏடுமா
சார் நீங்க எப்போ லைக் ஸ்டார்ட் பண்ணிடுவீங்களா 2 o'clock?
நான் ஸ்டார்ட் பண்ணிடுறேன், பட் ஐ
நீங்க
ஜஸ்ட்
ஸ்டார்ட் பண்ணிட்டு நீங்க
Good afternoon, ladies and gentlemen. My name is Tulsi Raj. I am from CII. We're just having some small technical glitch in getting in the first presenter, Dr. James. We're just trying to sort it out. Please give us a couple of minutes and we'll be right on it. Thank you. Sir, we can see you now, sir. You're able to hear us, please?
Yeah, in fact, but I'm unable to access the PPT. Hello?
Yes, sir. So we can see you. We can see you, sir. I think you're just trying to adjust your lens. Yeah.
So can somebody at your end operate the PPT?
Certainly, sir. Certainly, sir.
Sure.
You've sent it to us. Vishnu, you've got a presentation copy with you?
I think Sophia is working on it. So we will operate the PPT from our end.
Okay. So while I do the welcome remarks, sir, they will set it up. Is that okay, sir? Please.
Just 1 second, before I start the PPT, so I will be making the request to Vishnu, right? Vishnu Priya?
Yes, sir. You can send it to us.
Okay, I have already sent it to Ms. Sophia.
Okay, so you can just say next, sir. So you can give us the next thing. So when you say next, we will move to the next slide. So that will be our indication.
Excellent, absolutely. Fine then.
Okay, sir. So Vishnu, we can start?
Yeah, absolutely.
Okay. So Vishnu, while you set the presentation, I will do the opening remarks, Vishnu. So, ladies and gentlemen, good afternoon once again. As I was mentioning, my name is Tulsi Raj, and I am from CII. I am part of the International Linkages Subcommittee. It's a wonderful pleasure having all of you today to participate in this session. It's a very, very important subject, least to say, because it's a subject that is always interesting, irrespective of the external environment that we live in. But more than ever before today, in the uncertain times that the industry is going through, that individuals are going through, I think sessions like this, in terms of free trade agreements and export opportunities, are significant and essential for the economy to get back to its shape. And therefore, it is no surprise that we have excellent participation today from across the country. We have people from Pune from Guwahati, from Delhi, and from all the southern states. So it's a wonderful mix of people from various sectors, also mostly manufacturing, but also from services, from institutions. So it's a wide, diverse set of audience. And we're actually looking at this topic in a time when India is one amongst the top countries in Asia with the maximum number of FTAs either in operation, under negotiation, or proposed, right? And it is no wonder that a broad analysis of trade between India and its major FTA partners shows a significant increase in trade since the agreements have become operational, right? So India is working now to renew its agreements to make it more user-friendly, simple, and trade facilitator for businesses, right? So given the current pandemic, its impact on businesses around the world and the expected smart recovery by India next year, the government of India is negotiating FTAs with a number of countries slash groupings of countries, including the Mega Regional Comprehensive Economic Partnership (RCEP), which was I think India had a long discussion before pulling off. We are also, I think, the government of India is also working on the India ASEAN FTA to renew that agreement. So given that we are, of course, in the pandemic situation caused due to COVID, and also the resulting trade war between US and China, the collapse of the World Trade Organization's dispute appellate system, Brexit, which happened a few months ago, I think all this is working on the minds of people and the general geopolitical scenario of how all this will convert into either opportunities or challenges, right? And today we are extremely delighted and thankful to Dr. James. He's an excellent speaker, somebody with enormous amount of knowledge. I will just briefly introduce him to you. And more than everything else, he's been a friend for CII. He's been giving his time in spite of his busy schedule. And I think this is the third session he's doing for us in as many months. So thank you so much, sir, to have you with us today afternoon on a working day. Thank you so very much. I know you don't like extremely brief introductions, but I will still make an attempt to keep it as short as possible, maybe in a minute's time. Dr. James has 2 decades of experience in the field of international economic law. He advises the government on various aspects related to international trade and investment law. He has worked with leading law firms, corporate firms, and he was part of the Indian delegation that appeared in recent proceedings on India agriculture products before the WTO appellate body. He has taught courses on international trade at universities in Brazil, Mexico, Australia, of course in Bangalore and in Kolkata. He's also a visiting professor to the Center of Development Studies at Trivandrum. Dr. James has a PhD in law from the National Law School, Bangalore. He also holds graduate degrees in law from the University of Cambridge, UK, the New York University School of Law, the United States, and the National University of Singapore. He's the recipient of the Cambridge Commonwealth Scholarship and has also served an internship at the Legal Affairs Division of the WTO, right? Dr. James has, as I was mentioning, has extensive knowledge in terms of the subject on FTAs and export opportunities. And as I was mentioning, somebody who is able to spend, despite his busy schedules, a lot of time for the Indian industry, is extremely passionate about letting the people in the industry know about what is happening, within the 4 walls of various government meetings. Whatever he is able to share that will benefit the Indian industry at this time, he will do. He has got a presentation. I also want to quickly introduce Mr. Sanjay Notani, who is here. He will be handling the second portion of today's program. He is, of course, partner with ELP, and he heads their international trade and customs practice. He is a member of the Supreme Court Bar of India and Maharashtra and Goa Bar Council, American Bar Council, and has the distinction of being appointed to the American Bar Council's Bar Association Steering Committee of the Exports Control and Economic Sanctions Committee, representing Asia. His advisory work includes appellate litigation to obtain trade remedy reliefs from unfairly traded imports and anti-dumping, countervailing, and safeguard duty proceedings. He also provides trade advice on various FTAs, RTAs being negotiated and signed by India. I'm sure we will get to hear a lot of information about these subjects going forward. He has advised business and industry associations on a wide array of issues related to SPF, SPS, and non-tariff barriers. He has in-depth experience in advising various multinational companies on import and export control as well as licensing issues, specifically the dual use of goods and technology regulations. He provides legal and commercial advice to corporates and governments on the inherent challenges in doing business globally, including the strategies to be adopted by global value chains. He has been recommended for his expertise in Chambers Asia Pacific, Chambers Global, and Legal 500 Asia Pacific. He has recognized as a leading expert by Who's Who Legal Trade and Customs and is featured in World ECR Awards for export controls and sanctions practice. He is also featured as a thought leader in Who's Who Legal. With these few words, I wanted to welcome Dr. James and Mr. Sanjay. We thank them for their time to interact with our delegates as part of this program. So thank you once again to all the delegates who have come in from across the country and to our speakers today. Over to you, Dr. James, please. Thank you.
Okay, so thank you, Tulsi Raj. It has been, there were plenty. I think this introduction was a very long one. Anyway, thank you again for cooperating with CII. This is my third program with CII in a matter of 3 months. So we really look forward to having a long-term association and also working with the industry in terms of expanding India's trade potential. So today I'm also very grateful to the two other organizing partners. One is ELP, Economic Laws Practice is one of the prominent law firms in India. I'm very grateful to him, Mr. Sanjay Notani. And the other partner is Center for Regional Trade. It is actually a sister concern working at the Indian Institute of Foreign Trade. I'm extremely grateful to Mr. Dr. Ramubedra Das for joining this program as well. So he will be taking his classes or sessions on the 27th. So let me try to give a bit of background actually. So the purpose of my opening lecture is not to really go into the depth of free trade agreement and India's engagement with various free trade agreement partners. My objective is to give a fairly broad brush idea about free trade agreements, their relevance in international trade at the moment, and what the industry can by and large expect from a free trade agreement. So now I think some of you might have heard about a World Trade Report, which came out this week, and the report paints a very sordid and a very disappointing picture for international trade. The World Trade.
Sir, I think you've gone on mute, sir. Please, I think you're on mute, sir. Please.
Oh, so can you hear me now?
It's better, sir. Yes, please carry on, sir. Please carry on.
All right. So I think that you had something, some of my opening remarks. I'm very grateful to CA, Mr. Sanjay Notan, and also to Dr. Ramubedra Das for this wonderful opportunity. So in my first talk, I'm going to give a bit of a broad brush idea about free trade agreements, what India can actually do in these kind of negotiations. So let's talk about a World Trade Report came out this week. The World Trade Report basically says that international trade is declining at an alarming rate. And according to this report, the international trade at the moment is actually the same level as it was in the 2009 period. And that's a really alarming thing because if international trade slows down, it will have an impact on most of the economies because trade is an engine of growth. And secondly, I just want to talk about India's engagement a little bit. So now, let me go to my PowerPoint presentation. Vishnupriya, can you actually put the PowerPoint presentation on screen? So I'm going to talk about free trade agreement and the role in the world trading system. So most of you know that the free trade agreement is basically an exception to the MFA principle under the WTO. Some of the prominent economists, including Professor CTIL, mentioned that there are termites in the system. So when we think about the termites in the system, the termites system, and that is actually a major concern with all the free trade agreements. Although they are trying to actually eliminate barriers to trade, duties, and other restrictions on commerce, at the same time, they will have a detriment. So that is why the relationship between the multilateral trading system anchored by the WTO and the free trade agreements, which are in plenty in modern times, will be easy one. And for every country, including India, the major challenge is actually operating these two systems at the same time, following multilateral trade negotiations on the one side, and on the second side, trying to trade with some of the industries, mainly countries which are actually adjacent to our country. So that is a major challenge. If you really look at the pattern of legal trade, as of now,
Sir, sorry to interrupt, Krishnapriya here. Sir, can you just send us the presentation to my ID, sir?
I have already sent it to Mr. Tulsiraj.
Could you just send it to Tulsiraj?
I have already sent Vishnu, I have already sent it to him.
We have that he can you just mail it to us?
We have not received it, sir.
I think you actually bounced.
Can I the email ID now? Can you send it to us, sir?
I just text my email to Mr. Jitendra.
Anyway, but I don't have the time to run the presentation, so I will speak in an extempore manner because I have some time to run Hello.
Sure, sir. Sure. No issues. Right?
My deep apologies to the entire audience because I think this presentation should have been uploaded earlier. Anyway, I'm just going to talk a little bit about the regional trade agreements in the context of the multilateral trading system. When the GATT 1947 was signed, at that time, 70 years ago, there was not even one regional trade agreement. Maybe you can argue that there was one trade agreement between Mexico and the United States signed in 1943. But by and large, the world did not have any kind of regional agreements. Then came in the European Economic and Steel Community, followed by the 1962 Rome Treaty, which actually established the European Union. That agreement is basically, I think, I would say, the harbinger for free trade agreements or maybe economic integration agreements in the world. And until 1993, I think there were very few free trade agreements. But after the World Trade Organization came into effect in 1996, we have actually seen a spurt of regional trade agreements, customs union, and free trade agreements. So the terminology of free trade agreements, regional trade agreement, customs union is a bit confusing. If you really look at the WTO agreement, there is only reference to the term customs union and free trade agreements. And that is actually provided under Article 24 of the GATT. It talks about customs union and free trade agreement. Now, some of you may actually ask the question, what is the difference between the two? In the case of a free trade agreement, the objective of the agreement is basically to reduce duties or other restrictions on commerce. In one way, I would say the most important objective of a free trade agreement is to eliminate or reduce duties over a period of time. On the other hand, the customs union has got a different objective. In the case of a customs union, the member countries of the customs union will have a single common external tariff. The most important customs union that we can think about is the European Union. So until recently, it was a 28-member union. Now it is a 27-member union. And there is harmonization on the external duties. So the European Union has got a common external tariff. So sometimes a product from India may go to France. Sometimes it may go to Spain, or sometimes it may go to Portugal. But the rate of duty applicable to Indian product at any of the customs border in Europe will be the same. And once the products are actually cleared from customs, the products can move freely within the community market. So the European Union is actually one of the most, you can say, one of the most ambitious level of economic integration. Some of the trade scholars would actually call it deep integration. So on the other hand, the free trade agreements are not actually examples of deep integration. The free trade agreements only lower duties on the movement of goods. And in certain situations, it may actually provide for elimination of restrictions on services as well.
Sir, I've just uploaded the presentation. You want to use it, sir?
No, I don't want to use it because the time is very limited.
Okay, fine, sir. I'll just.
Yeah. So in the case of most of the free trade agreements, generally, as I mentioned, the duties on most of the products will be eliminated over a period of time. In the case of services, some of the restrictions on services would be eliminated over a period of time, but the amount of barriers on services trade is significantly much higher than the amount of barriers on goods trade. Maybe the only example which I mentioned is the European Union, but look at the North American Free Trade Agreement. It is actually an agreement dealing with the movement of or the liberalization of trade in goods. Now, the NAFTA agreement in 2020 has been updated to a US-Mexico-Canada agreement. That agreement is much more comprehensive than the 1993 NAFTA. In addition to goods and investment, there are many other areas where the USMCA is actually providing additional disciplines. So in a way, as world became much more complicated, as trade happened not only in goods but also in services, and with the expansion or with the advent of the digital trade, the kind of issues dealt with or dealt under the trade agreements have become much more complex. And that is why, Mr. Tulsiraj just referred to a mega regional agreement in his opening remark. A mega regional agreement is a much more comprehensive agreement than a free trade agreement. It actually deals with a large number of harmonization matters or harmonization efforts. And that is why these agreements are actually called deep integration agreements, or agreements that actually deal with behind the border measures. So all of you know that a free trade agreement in the general sense will only deal with customs matters, customs duties, and the related aspects. But a modern free trade agreement, generally in the nature of a mega regional agreement, will deal with a number of harmonization issues. To give an example, intellectual property rights. So once the members to a free trade agreement also signs a chapter on intellectual property rights, the IPR matters within that free trade agreement block will be harmonized. So now we think about the USMCA, which has actually come into effect very recently in June 2020. That agreement has got IPR chapter, and the United States, Mexico, and Canada are required to provide a single or harmonized kind of protection for IPR issues. The USMCA has also got a chapter on automobiles. So that means with respect to the automobile policy, the three countries are trying to harmonize their practices. With respect to biological products, like certain pharmaceutical items, the USMCA provides a 10-year protection in the agreement. With respect to state-owned enterprises or public enterprises, there is a framework in that agreement. That means the state cannot actually allow a public sector undertaking or a state-owned enterprise to operate outside commercial considerations. So the simple point is that a modern free trade agreement has actually become much more complex, detailed in scope, and ambitious in nature when compared to a free trade agreement of the NAFTA type. So that is why, with the new issues like digital trade also getting into the domain of international trade, the scope and nature of the free trade agreements are only expected to enhance and widen in the future. So now let me, since I'm talking about India's own free trade agreement, I should say that India, people say that India has been the last warrior of the multilateral trading system. India was a founding member of the GATT 1947, and for decades, India actually reposed its faith in the multilateral trading system. India was actually India's first, you can say first free trade agreement was signed with Sri Lanka in 1998. So that is actually, India was part of the Bangkok Pact as well, but that is not a typical free trade agreement. So after signing the India-Sri Lanka Free Trade Agreement in 1998, in the decade of 2000, India signed a few other trade agreements as well. The one agreement is actually the BIMSTEC agreement. The second was SAFTA. In 2004, India signed an agreement with Thailand. That agreement was actually limited to 82 products at the time. So that means when the agreement was signed in 2004, the duties were actually lowered on 82 products, but that agreement has not been finally or eventually concluded. Again, India signed an agreement with Chile in 2004 or 5. That agreement also included just 400 ore items. So you have to again imagine that, in the field of international trade, there are nearly 6,000 items at the 6-digit level or 11,500 items at the 8-digit level. So generally speaking, whenever a country signs an agreement, it will have to liberalize trade substantially on all the products. So when we think about substantially all the products, you have to remember that the duties on a vast majority of the products is actually eliminated over a period of time. So the India-Chile and the India-Thailand agreement were basically partial scope agreements, or sometimes some people call it a preferential agreement, in the sense that it is an extremely mini preferential agreement. The product scope was very narrow and thin. Again, in the decade of the 2000, India signed an agreement with the Mercosur. Again, it has not been completed. Then the most important, I would say, the most important efforts taken by India was actually part of the look east policy. So when Vajpayee was the prime minister of the country, he took an effort to sign an agreement with the Singapore. That was way back in early 2000, around 2004, I think. Then with the ASEAN, with in Japan. So the three most important agreements that India had signed, actually were concluded in the early decade of the 2000. So the India-Singapore agreement came into effect. Then the India-Korea agreement came into effect. Then the Japan agreement came into effect. The Japan agreement was slightly older, I think. Then India also started a negotiation with the European Union way back in 2007. It is another factor that this, this broad-based agreement, it was a comprehensive agreement, is still not concluded, although they have actually moved 13 years after initiating the negotiations in 2007. The most important thing about the India-Singapore, the India-Korea, and the India-Japan agreement, and later the India-ASEAN agreement, is that these are very comprehensive agreements. They are not purely limited to goods sector. They cover services, they cover intellectual property rights, some cover even electronic commerce in a minor way. So in that sense, these agreements are, really ambitious in their scope and nature. And the overall objective is to have some kind of an integration. When we think about the ASEAN agreement is perhaps the second best example after the European Union in terms of regional integration. And why is actually regional integration important? Regional integration is important in order to promote a global value chain and regional value chains. So most of you working in the industry know pretty well that international trade is not actually decided by comparative advantage in one particular product. It is actually decided by the partners and the lead firm in the global value chains. So the name of the game is how a particular country can become part of the value chain. That will depend upon a number of factors. That will depend upon the investment choices. That will depend upon the comparative advantage in labor and other resources. So India, unfortunately, is not a major player in the value chain, business. That is something I think the government is taking efforts at the moment to basically address. So in any case, as I mentioned a while ago, our focus was to become integrated with the Southeast Asian region, and to an extent, India's agreement with the 4 countries, or maybe I would say with the ASEAN bloc, with Singapore, with Japan, with Korea, and later with Malaysia, cemented that approach. And later in 2012, I think in late 2012 or 2013, India started the negotiation with ASEAN plus 6 countries, ASEAN plus 5 countries. The 5 countries actually are situated around the Pacific Rim. They include Japan, they include China, then Korea, Australia, and New Zealand. So there's also some kind of a historical perspective to the RCEP negotiation. When Obama was the president in the United States, Obama initiated the Trans-Pacific negotiation. So the Trans-Pacific negotiation again actually was a negotiation between the Asian countries and also between the American continent actually. It includes both North America and South America. So that agreement was signed in 2016, I think. But it took it is perhaps the most important agreement. Some people call it the gold standard agreement. Some others actually call it the 21st century agreement. So the TPP agreement is still considered as the most comprehensive, the most deep, and the most harmonizing agreement ever negotiated by any party. So and one important point about that TPP agreement was that it was an agreement, some people say, to exclude China. So when the United States was negotiating that agreement, many other countries also thought that there should be a counterfoil to the TPP. And that is perhaps the reason why the RCEP negotiations also took momentum in the, around 2012-13, around that time. That negotiation went on for a fairly long period of time. 28 ultimately, what happened in the background of the agreement. I do not know what has happened to the agreement. Some people say that this agreement may fail. I do not know. So that is actually a political issue. But at the same time, we can tell very conclusively that some of the mega regional trade agreements, including the TPP, did not actually deliver what it promised, for the simple reason that some of the countries basically withdrew from the agreement. In the case of the United States, President Trump took a decision to withdraw from the agreement on the first day of his office, first day in office, and thereafter, some of the other countries which were participant to the TPP negotiation gave a different nomenclature called the Comprehensive and Progressive Trans-Pacific Partnership Agreement. It is called the CPTPP. That agreement has still not come into effect. So this is basically to reiterate the point that these mega regional agreements did not deliver what they promised, including both the TPP agreement and also the RCEP agreement to an extent. There was also an effort around the same time to have a transatlantic agreement. It is called the TTIP, the trans. I mean, I don't exactly remember the full name of the agreement. It was an agreement between the United States and the European Union. Again, it was actually considered to be a deep integration agreement, but because of political issues within Europe and also within the United States, the efforts to conclude that agreement was aborted. So that is why the mega regional agreements, they promised a lot, but delivered very little. So now, let me actually say a few things about preferential trade as well. So I gave a bit of introduction about the WTO in the beginning, and I mentioned the fact that India is actually a loyal participant or a loyal member of the WTO, in the sense that India has been supporting the multilateral trading system for a long time. And I also mentioned that, by quoting Jagdish Bhagwati, I mentioned that free trade agreements can actually be called as termites within the system, because free trade agreement, despite their trade liberalizing objectives and outcomes, to an extent will destroy the multilateral trading system. So that's why it is a very uneasy relationship. When you actually give more focus to the free trade agreements, then the multilateral trading system will definitely suffer. So, while actually looking at these issues, there is some line of an argument that the free trade agreements can also be building blocks. So, to the extent they actually liberalize trade or remove the restrictive regulations on commerce or harmonize standards in sanitary or phytosanitary trade, it is possible to argue that they actually work as building blocks or stepping stones to a free or a liberal trade order. So that is actually one belief. But the WTO system also provides some kind of a mechanism, some kind of an internal mechanism for preventing the proliferation of PTAs. The one requirement is that when two countries form a regional trade agreement or a preferential trade agreement for that matter, they cannot actually create or maintain more restrictions on trade against third parties. And in international trade economics, some of you might have at least heard about the problem of trade diversion. So when a trade agreement is actually formed, the trade agreement will basically enable a country, a less efficient country, to actually displace a product coming from a more efficient country. So that is actually the problem with the trade diversion. But sometimes the free trade agreement can also create more trade. It can actually make a particular country more competitive. So while looking at that point of view, every country that is providing finished goods or even intermediary products may actually require primary products in order to do the processing. So to an extent, getting the inputs at a lower rate, at a lower cost, will actually make the country much more competitive. So that is why many countries also believe that a certain amount of unilateral trade liberalization or a trade liberalization through an FTA route, which actually brings in certain amount of reciprocity, is always good for the country. So that is why I said, it is a very balancing exercise. While the multilateral legal order is much better than a preferential trade order, the multilateral trade order also moves at a very slow pace. And that is again one of the reasons why the free trade agreement gathered the prominence and the momentum in recent times. Just to give some more evidence, the Doha round of multilateral trade negotiations were launched in 2001. In 2020, nobody knows whether Doha round is absolutely dead or not, because there is no official closure of the round, but at the same time, de facto, the round is dead. And at the same time, new issues are actually coming up in the multilateral trade agenda. So in a way, the free trade agreements were also necessitated because of the failure of the multilateral trading system to deliver. The multilateral trade negotiations in the last 20 years has only produced one agreement, and that to an agreement of relatively minor importance called the trade facilitation agreement. So that is why the one way of actually achieving liberalization, economic cooperation and integration is basically a smaller group of countries, and that is why I think free trade agreements will have perennial attraction. So now, when we think about free trade agreements again, so in the context of WTO, I said it's actually a very difficult balance or delicate balance. But I should also mention that there is not even one country in the group of 164 members within the WTO that has notified an FTA to the WTO. So which means all the 164 members of the WTO have signed at least one FTA. So way back in 2015, during the time of the Nairobi Ministerial Conference, the WTO members actually mentioned very clearly that the FTAs, the free trade agreements, are complementary and not a substitute for the multilateral trading system. So this is again one point which you have to remember. While pursuing free trade agreements, we have to make sure that they are not purely preferential in nature, they on the whole achieve or strive towards liberalization of trade and harmonization of standards. So now I just want to talk about some of the issues related to free trade agreements. The one important issue related to free trade agreement is that it is basically the rules of origin. So we know that in the case of free trade agreements, only the products which actually originate in a particular country can claim the benefit, can claim the preferential benefit under the free trade agreement. So that is why most of the countries have got their own rules of origin to determine whether the product actually belongs to the free trade partner or not. And the key test, at least in the context of the rules of origin, is substantial transformation. So if a product is basically transshipped through another country, and if that country has got an FTA with the importing country, then of course there is an incentive for the other party to gain the benefit under the free trade agreement. But the parties to a free trade agreement will also make sure that the products of third parties or parties which are not actually members of the free trade agreement or the customs union do not get the benefit. And therefore, they require some kind of a test. One is actually called the substantial transformation test. This test is applied through two important criteria. The one criteria is basically change in tariff heading, change in tariff headings, in fact. So when we really look at most of the free trade agreements, there are two important elements. One is actually change in tariff subheading, and the other is change in tariff heading. The change in heading is basically at the 4-digit level, and the change in tariff subheading is actually at the 6-digit level. India has signed a large number of FTAs, which I mentioned earlier. In most of India's free trade agreements, the criteria for conferring origin is change in tariff subheading, or people call it CTSH. The other important element is that there should be a certain amount of minimum value addition. So what is actually minimum value addition? The minimum value addition in certain cases may be 40%. A generally agreed value addition criterion is 40%. In some agreements, it may be 35%. But below any percentage below 30% is considered to be too little. So these terms like what is actually substantial transformation is fairly vague in nature, in the sense that no one has clearly defined what it is, and it may also depend upon the products in question. So if you look at any kind of free trade agreement in modern times, let me actually look at the USMCA, the United States Mexico Canada agreement signed in 2020. That agreement has a specific rules for textile items. Even under the North American Free Trade Agreement, there was actually a yarn and a fiber forward rule. So for a textile item to get the preference under the concerned free trade agreement, the yarn or the fiber, which was used for making a fabric or an apparel, should be sourced from their FTA partner. To explain it a bit more, so if the product is actually manufactured in Mexico, and if the fiber is coming from China, obviously the tariff benefit on the finished product will not be available under the NAFTA. So many countries are actually coming up with the different kinds of rules of origin. The United States has signed an agreement called the DR-CAFTA, the Dominican Republic CAFTA agreement. That agreement has got a very interesting rule of origin called the pocket rule. So in the case of a shirt, in order to confer the origin, the pocket should have been stitched in one of the participating countries. So the purpose is here, very clear. The purpose is basically exclusionary, in the sense that if one of the products, if one of the key raw material or input for the production of a product, if it is not sourced from that particular region, then the benefit under the FTA will not be extended. So the rules of origin has been an extremely complex area. I mean, there are many product-specific rules of origin. It happens in the field of textiles and clothing, as I mentioned. In the field of petrochemical items, it is fairly common. There is also a very important rule of origin. So think about maybe a fish product coming from another country, or maybe an agriculture product coming from another country. This product need not be a processed product. So in those kind of cases, the concerned principle is actually wholly obtained. So the product should be wholly obtained from a particular country. So a fish, or maybe you can say a certain kind of an agriculture product cannot be they cannot be separately sourced from two different parties. It has to be wholly obtained. So these are some of the benchmarks which are fairly commonly used in order to confer the benefit under the regional trade agreement. So today I'm not going to speak more about the rules of origin. There is a special dedicated session which will be organized on the 27th by Professor Ramabindra Das. That session will provide specific rules on rules of origin. One of the most important concern here is that despite the proliferation of free trade agreements, the amount of trade that is actually happening through the preferential route is still very low. More than 50% of the trade happening globally is actually through the MFN route. So then people will ask, what is it? Why is it so? The major reason is that the amount of awareness, maybe among the industry, among the exporters or traders, about the rules of origin provision may be very little. The second reason is that sometimes the preferences may not be significant. In the case of a country like India, the peak rate of duty may be significantly higher. But if you look at many other countries, the MFN rate of duty and the preferential rate of duty may not be very different. They may be maximum 1 to 2% different. So in those kind of situations, it may not be prudent for a country or for a businessman to actually spend significant amount of time in compliance matters. Now, I would also like to talk something beyond the free trade agreement. So when we think about a preferential agreement, so the free trade agreement is actually only one form of a preferential agreement. A large number of products from different countries are also, I think, entering other countries through preferences. Some of you might have heard about the generalized system of preferences, or what you call as a GSP. The United States had GSP on 5,000 odd tariff lines. The European Union still has a GSP. Then many developed countries have got GSP programs. And under the GSP program, a product coming from a developing country or a least developed country may actually enter the market duty-free. In the context of WTO also, there were many, there were a large number of cases dealing with preferential trade matters. One of the very interesting cases was actually the European Union banana case. Why is that case very significant? It is actually a case where the battle was basically for getting the preference. So that case was actually about banana trade. And if you look at the growers of banana, most of the bananas actually are made either in Latin America or sometimes in African countries or in Caribbean countries. And most of the African countries were actually colonies to the European Union. And they signed an agreement called the Cotonou Agreement. So under the Cotonou Agreement, the banana products or processed items actually enter the European Union market at a preferential rate of duty. And that was, you can say it's a preferential kind of an arrangement. At the same time, the Latin American bananas, if they come from Honduras, Ecuador, or Venezuela for that matter, or Colombia for that matter, they did not get the same kind of a benefit in the European Union market. So they filed a case against the European Union in the WTO saying that their products are actually discriminated. Strictly speaking, it is a violation of the most favored nation principle. But you have to remember that there is something called an enabling clause in the context of the WTO. The enabling clause provides developed countries to provide preferential access to products coming from poorer countries. It is actually, in a way, it is something quite similar to giving a gift. But if you can actually give a gift only to some select people. So in order to overcome this problem with respect to the MFN status, the GATT contracting parties way back in 1979 signed an instrument called the enabling clause. So under the enabling clause, developed countries can actually provide preferential access to products coming from poorer countries. And that is actually one of the permissible exceptions to the MFN principle under the GATT. So now, while coming back to the GSP schemes, the United States has been providing significant amount of GSP benefit to India over a period of time. They started the GSP program way back in 1974. The European Union has also been providing benefits to India and many other developing countries. Interestingly, the United States in 2019, on May, I think 31st, 2019, removed the GSP benefit available for Indian products. The European Union has also graduated a large number of Indian products from the GSP category. But at the same time, both these countries provide preferential access for products coming from India's neighbors, say Bangladesh. Bangladesh is a least developed country, and the Bangladesh's items can actually enter the European Union market under a zero rate duty, under a program called Everything But Arms. Stated simply, under the Everything But Arms scheme, anything other than arms can enter the European Union at zero rate of duty. So we know that even a 3%, 4% duty can be significant when the level of competition is very high, or when every exporter is actually looking above the shoulder of the competitor to gain a control in the market. So that's why even a 1% or 2% tariff preference can be extremely sensitive in international trade. The GSP schemes are not going to go away, but there is a danger that India, actually graduating from a low-income developing country to a middle-income developing country, may lose some of the GSP benefit going forward. So that should be one concern for the industry. In order to overcome this, the industry will have to remain more competitive. The government will have to provide better infrastructure, bridge some of the inefficiencies related to the production or factors of production in India. So these are some of the issues which I just want to flag in today's talk. Unfortunately, I have got a meeting at 3 o'clock. So what I will do, Dr. Ramabindra Das will be giving a lecture or giving a talk on 27th. If there is any possibility, I will also come in order to complete my discussion on 27th. But in the meantime, I think we have got Mr. Sanjay Notani, a very experienced practitioner of trade remedy in India. And trade remedy is a very important thing, because whenever a country signs a free trade agreement, there is a huge potential of imports from the other country coming into their market in significant quantities. So in order to prevent this surge, many of the free trade agreements have got safeguard provisions. Sometimes it is called a bilateral safeguard provision. So I would encourage all of you to listen to Mr. Notani. He is a very experienced practitioner. In the meantime, I have got 5 minutes, so I will leave around 3 or 5. So if you have any questions, then I'll wait for your questions. In the alternative, I will actually meet you on the 27th.
Thank you for your speech. Sir, we'll have a question and answer session now. We can take 2 to 3 questions. There is one question in the chat box. If you can look at it and answer to that.
Mr. Priya, I can't actually hear. Can you be a bit louder?
So we'll have a question and answer session now, which for
I think for 5 minutes, I will actually be there. I have a meeting at 3 o'clock.
All right.
So I'll wait for 5 minutes, and after that, if anyone has any questions, then I will respond to them on 27.
Okay, fine. So we will share the email address to the participants if they can post it.
Yeah.
Their email ID. Thank you. Thank you very much. So we'll be having the next presentation from the next speaker,
Yeah.
Mr. Sanjay Notani. Have you joined, sir?
Yes,
Mr.
hi.
Sanjay? Yeah,
Yes.
hi. Yeah, hi, sir.
Hi,
Welcome,
Sanjay.
welcome, sir.
Hi.
Thank you. In fact,
Hi, James.
nice to see you.
So, James, thank you so much for giving us this opportunity to touch upon one of the most important topics of the times, because given the protectionism, which is completely sort of increased by notches up in this period of time, it's interesting to speak about these issues, and particularly from an FTA perspective, like you mentioned about bilateral safeguards. As well as also this opportunity is also very important to be seen that tomorrow, when our Indian industries and friends start exporting these goods to other FTA partners, what should they be expecting? What could happen? How do you sort of address these issues? And therefore, it's important to take this information from both the sides. And as James mentioned, that the a level of knowledge and information on some of these aspects, when you work upon preferential, is too low. It is important not to be sort of taken on the side with these kinds of measures. James, I think there is a question for you.
Yeah. In fact, I should say that my computer was not working, so I'm actually speaking from a mobile phone, so I can read.
Okay. Can I read this question for you, James? So it will help you to answer. This question is raised by Ritika Changia to say Indian vehicle attracted duty of 6.5% under GSP with EU until 2016, which was discontinued after a threshold of exports was achieved and the duty became 10%. How can such things be avoided?
Okay. Right. To give a simple answer, the GSP is actually it is basically tailored to the development state of the country concerned. So even in the United States, there is actually a test called the competitive needs limitation test. So if Indian gems and jewelry actually exceeded a particular threshold of the US imports, they will remove the benefit. So in the sense that the GSP is only trying to help a poor country or a developing country or an LDC for that matter to actually get into that market. Once it becomes a dominant or a major player in the market, then most of the countries will actually graduate out that particular industry. So this is very common. I mean, for LDC countries, they do not generally provide for graduation. But in the case of low-income countries, like India, if a particular product, although India is actually a low-income country, if a product acquires a defined share in the market concern, then they will graduate on the product concern. So it is actually perfectly compatible with the GSP scheme or the enabling clause under the WTO. So this is not an area where we can actually take a dispute with other countries.
Is there any other question or?
Yeah, there is a question from Mr. Vinod Mishra.
Yeah.
Under FTA, there are any concession on import of fabric from customs, USA and Europe, and ceramic from China and Italy?
Say it again. Can you repeat the question?
Under FTA, there is any concession on import of fabric from customs, USA and Europe, and ceramic from China and Italy?
No, in fact, I couldn't actually hear that question properly.
Okay. Is it,
Can
now
you say
it
it
is
again?
audible, sir?
Yeah.
Okay. So under FTA, there are any concessions on import of fabric from USA and Europe and ceramics from China and Italy?
If I understand the question correctly, I should also tell very clearly that India doesn't have an FTA with any of the countries mentioned here. The United States, the European Union, or China for that matter. So there is no concession rate or duty. If I understand the question correctly, because I only heard parts of it.
Sure. Okay, sir. Sir, there is one more question from Ms. Keertana. She has a long question. For example, now we are having a sweet shop in many areas, but still we don't build a factory. There was no necessary for that, but now we have planned to export our products to UK. So definitely we need to build a factory and it must contain R&D lab. How the construction of the factory would be? What are the norms to be followed for exporting the products? How to come to know what are all the products can be exported? Is there any license to get and certifications, etc.?
Unfortunately, I think this is too complex a question for me. I can't answer it because it requires a certain amount of. Sanjay, would you like to answer that question since you deal with the industry on a regular basis?
Yeah, what I will do is I will, while I'm giving my presentation, there is a certain brief period where I will be switching off as a speaker. So I will actually find a very quick answer to this. And by the end of the Q&A, I will give you the answer.
I think that will be better actually. So I should also tell you that, my system is not working properly. I'm unable to hear everyone. So what I will do, 27th, if there is any remaining question, I will try to answer.
Sure, sir. We will mail the questions to you. Mr. Tulsiraj will mail it to you if you can answer to them, sir. Thank you very much, sir. Thank you for joining.
I need to exit it. And Sanjay, thank you so much for coming in and, taking this session. I will catch you later.
Thank you, James.
So over to you, Mr. Sanjay.
Yeah, thank you. Good afternoon, everybody. First of all, I would like to take this opportunity to thank CII, and particularly given my interaction with CII has been since many, many years, and also given that I am one of the members on their committee, specifically looking on the issues of trade. So it gives me great pleasure to present this export clinic, especially on issues something which is well known around the world. Particularly, it is one of the most favorite instruments under the trade remedial agreements signed up at the WTO. And today it gives me also great pleasure to introduce my colleagues and partners, Mr. Parthasarathy Jha and Amrish Satyanathan, who will be also taking certain parts of the presentation explaining you on subsidies or countervailing duties, as well as safeguard actions, which are also one of the other trade remedial actions and instruments offered to us under the WTO, therefore also available to us under the FTA, and what are the differences between these instruments at the WTO when we use the WTO agreement and instruments. How does this work under an FTA? Because ultimately, given the wafer thin margin the industries are working on, basically, given the whole geopolitical system, overnight, the business, either it can turn into a full opportunity or it can go completely on the other way, depending on some of these things, the way world is today, and protectionist measures are all-time high. So I will quickly go through the presentation, explain you certain concepts, which of course James has done that, but I will take the liberty to also explain some of these things because it is very important that conceptually these should be very clear. So first of all, what are the FTAs and RTAs doing under the WTO? Because we thought WTO basically is a multilateral fora taking into consideration all the countries. However, there is a principle known as MFN principle, which is known as the most favored nation principle. And the GATT in 1994 recognizes this principle, which says that if an advantage or a favor or a privilege or an immunity is granted by one party to any product originating or destined for any other country, the same treatment should be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other parties. That means if today I give a concession to any one country, whether it is a country under the multilateral WTO or if it is under the FTA, I should treat everybody and give everybody the same treatment. However, there have been derogations from the MFN principle, which are the basis actually of forming the FTAs. And FTAs is nothing but a mutual recognition of allowing certain more concessions, which is not otherwise available to all the 160 members of the WTO. And therefore, this is a kind of an exclusion. Article 24 of the GATT for goods recognizes this, and Article 5 of the GATT, which is the agreement for services, also recognizes that. And this is where it is. So FTAs and RTAs have been allowed under the WTO GATT agreements. Article 24 basically is very simple. It says recognizes the desirability of increasing freedom of trade by the development through voluntary agreements of closer integration between the economies of the countries parties to such agreements. The need for all these FTAs came only from the basis of regionalism, because it makes sense that today, if we are neighboring countries and if you are efficient in something and the other country is efficient in something, rather than both of you all producing the same product, it's best to trade. And therefore, this whole mechanism of regionalism came forward. There are blocks like Europe, there are blocks like Middle East, there are blocks like North America, which includes right from Canada right down to Mexico. There are blocks like ASEAN, and that is where the need of all these FTAs and RTAs came. Now, what are the different kinds of RTAs? They can be either a symmetrical or an asymmetrical. Symmetrical means when exactly I give the same kinds of concessions between partners to each other, and that is where this works as a symmetrical. Asymmetrical means there are certain concessions which we may decide not to give, or which we may decide may be liberalized over a shorter transition period. So giving you an example, suppose for us dairy products are very important, and or automobile are very important. Now suppose if we sign an FTA with China, we will tell China that yes, I'm happy to give you concession on dairy products. So rather than giving you a concession of 3 years, where actually the duty from 10% will go to 0% in 3 years, I'm happy to give you that agreement and a concession for a shorter transition period, saying 1 year. But somewhere on the automobile, I may say, no, give me 10 years, because actually I'm giving you some concession there. So as far as my other product is concerned, I want a longer transition period. So those are the kinds of RTAs which we have, and those are the kinds of terms and conditions which we can actually negotiate. The main idea is that objective of trade liberalization, and RTA is selective towards one particular country or a group of countries. So if you remember, James was talking about RCEP. So one is basically the ASEAN countries had a very forward-looking thing as part of the ASEAN, because they already have an agreement. But now, given that these 5 new countries were supposed to be joining RCEP, so how exactly would ASEAN deal with either India, China, Australia, New Zealand? So that is where these things work. These are the types of trade agreements, and very interesting to understand, because I remember there are certain questions which you have for US, which you have for EU, which you now will have for UK. And you're also reading in the press that India is forward looking now to signing some of these agreements with United States, whether it's a very small focused kind of an agreement, or we could be signing a full blown agreement, comprehensive agreement with Europe, or we can have a very limited agreement of only preferential trade agreement with country like UK after Brexit. Now, what kinds of agreements are there? Because tomorrow, as industry, it is very also important to understand that when India is negotiating these agreements, depending on which are the products being negotiated, how they are going to be negotiated, and whether it makes your purpose to be sorted, given that if UK remains one of the important markets for you, then how do we deal with these situations? And interestingly, from an industry, it's also very important that suppose tomorrow India signs an agreement with UK and we decide to give them concession wherein automobile cars are allowed to come from UK, given that we may have Rolls Royce sitting there or we can have Range Rover sitting there and we want to come. Now the question here is what James was talking to you about these value addition norms upon these rules of origin, because ultimately if European Union is sitting next to UK, are there very important, engines? Are there any chassis? Are there any braking system? Auto components are just being assembled in UK, and therefore UK actually uses this agreement to sell these automobile cars to India? These are certain questions we all have. Now, while these are some things, areas which we will all focus next week on the 27th, but from our perspective, it is important to understand what kinds of agreements matter. So very quickly, I'll just take you through some of these agreements. So framework agreement is basically nothing that prior to the negotiating trade, potential trading partners sign like a framework agreement which sets the period for future substantial liberalization by defining the scope and provisions of orientation for some new area of discussion. India in the previous rounds has done this with ASEAN and Mercosur, a preferential trade agreement. In this agreement, two or more partners give preferential rights of entry to certain products. So this is reducing only duties on agreed tariff lines. So very, very tiny lines. We may decide only on 100 tariff lines. We may decide to give this concession. So these agreements are like India-Afghanistan PTA, India-Chile PTA. Next comes FTA. These are very extensive forms of free trade agreement, which actually decides to reduce or eliminate tariffs on substantially all trade, and which also involves capital, services, and investment. Goods are not subjected to liberalization. We have a negative list. India has FTAs like with ASEAN, with Sri Lanka. Then comes CEPA and CESA, which is Comprehensive Economic Partnership and Cooperation Agreement. These are similar to FTA, but not only limited to goods, but also services, and they are much more broader than FTA. So we have had with India, Malaysia, CESA, we have India, Korea, CEPA. These are certain agreements. Last and not the least, customs union. Best example, European Union. So this is an agreement where all partner countries agree to trade at zero duty among themselves, and this is where the trade happens. And these are different forms of FTAs. Very quickly, these are the trade agreements. And there are clearly lines you would get to see in blue, which are the goods notification. Red is for the service. And these are the kinds of agreements which we have seen right from 1994, highest peaks being in 2008, 2010, 12, and we are back down to absolutely almost negligible, given 2020 being in the last 1 or 2 years, we've seen geopolitical issues taking more than industry issues. We are also seeing now this year being the COVID. So, these are the kinds of growth which we have seen, the types of trade agreements which are registered and which is part of the RTAs all around the world. This is where we have, as far as India's trade agreements are concerned, very few, very less, mainly on goods, as we said. Services notifications, like we said with Korea, or we have with CEPA with Singapore. Very few agreements which also deal with services. And these are some of the agreements which we have in force as far as India is concerned. So this is a list of all the agreements which we have. Somewhere they are PTA, somewhere they are CEPA, somewhere they are FTA. This is the list of all the agreements. I will not sort of labor too much time onto this. And in any case, once this presentation is available to you, you can clearly go through the same. These are all the existing ones which we have available with us. India has also right now commenced some of the discussions. One is BIMSTEC. BIMSTEC is nothing but an agreement which we have Bay of Bengal, which includes countries like Bangladesh, India, Sri Lanka, Nepal, and we are trying to see how more we can make it stronger. We have the European Free Trade Association in India, which is trying to achieve an FTA. We have EU India, we have India, South Africa. All these are part of some of the negotiations with countries which we have begun. We also hear that with USA, we are planning to do that with UK. In the last few weeks, it has become very strong that negotiations would want to start as early as possible with Australia. Mr. Modi has agreed that we should also be looking with an FTA with Australia and some of these new countries. I wouldn't say departing from the look east policy, but surely important trading partners for the present and for the future. Now coming to the main topic for the day, which is trade remedy measures. These are instruments given to us under the WTO, and some of these instruments we also sort of clearly follow in part of our FTA agreement. So whether you do an inbound or you do an outbound exports, these are certain principles, these are certain nuances and the manner in which these instruments operate, whether the action is against a WTO member or the action is as against an FTA member. These are trade remedy measures which we have against some of the countries. Now, if you see on this pie chart, products for which concessions have been granted under India's FTA, which is basically Korea, Japan, and ASEAN, 81% is only as far as these products are concerned, and we have had actions. Products that are excluded from concessions under the India FTA is about 19%. So you can see how exactly India, being one of the countries which uses the trade instruments such as anti-dumping and safeguards and subsidies to the highest as compared to the rest of the other countries. This is a sort of a pie chart showing maximum kind of cases have been under anti-dumping, which is almost 87% against the FTA partners. Bilateral safeguards is about 4%. CVD, which is stands only at 2%, but my sort of foresee is that this will increase very high in the near future. Safeguards is about 7%. These are the kinds of actions, and giving you a little more information on the kinds of products against the FTA countries, what kinds of instruments we've used and what kinds of products are there. So once you talk about anti-dumping, you will see that as far as the anti-dumping is concerned, caustic soda from Korea, hot rolled flat products of steel from Japan, Korea, and Indonesia. Japan, independent country. Korea, we have an independent FTA. Indonesia is part of the ASEAN. And the anti-subsidy, that means CVD action on continuous cast copper. We have a global safeguards on solar cells. That means nobody, whether you are an FTA or whether you are not an FTA, you have a global safeguards. That means anybody bringing in solar cells within the country, there are duties on it. And bilateral safeguards, that means we will, in the concession which we are given under the FTA now is taken away or withdrawn for a particular period. And these are the chemical products on which we have duties withdrawn, which is phthalic anhydride and polybutadiene rubber from Korea. This is just again some statistics on the kinds of products and which kinds of sectorial comes under the trade remedy measures. Now coming to the WTO, these agreements which are here, of course, the main sort of theme of signing the WTO as part of the signatories was committed to free and fair trade. but this also brought us to bringing down certain trade barriers. However, there could be situations as such that because of bringing down these tariff barriers, there are certain countries or who would not play by the rule book, because ultimately there is a rule-based process which we all need to follow. And this exposes this tariff concession, which we have multilaterally agreed between all the countries, or particularly under an FTA, may expose certain domestic industries in the importing country to be potentially, face unfair trade practices such as dumping and subsidy. And these are the agreements which we are talking about. So anti-dumping, of course, remains the most used instrument, but we also have anti-subsidy and safeguard measures, and these are all tariff-based. Apart from that, we have certain non-tariff barriers like standards, SPS measures, TBT agreement, TBT trade agreements, and certain instruments in the manner which we actually try and stop imports coming into the country. So one recent example where we see a lot of action in the news is about the standards being now proposed by India, and which is basically headed by the Bureau of Indian Standards, where actually we apply some of these standards in such a manner that we try and limit imports into the country and ensure that the trade seems to be rebalanced back in the favor of the domestic industry. Now, very quickly, let me explain you what is dumping and how do we want to sort of understand this concept. While there are some nuances to it, but it's very important to understand the principles of certain key interpretations as to what is dumping, what is injury, and what do we call dumping. And I will, given that today this presentation is to people who are part of the industry, and I will therefore try and ensure that the presentation is particularly from your understanding concept, from your business perspective, and where you understand commerce day in and day out. So anti-dumping measures are nothing but unilateral remedies applied against injurious dumping. What is dumping? Now, dumping, let me give you a very simple example. Suppose Japan is exporting a car engine to India, okay? Now, problem is that the car engine has two kinds of benefits given to them. So let me explain you these two types of benefits. One is, of course, we have an FTA with Japan. So these engines who otherwise would be coming at 20% duty now come at 10%. So that is because of the FTA. But the other problem is that because they are coming at 10%, ultimately they have better concessional import duty rates as opposed to the rest of the country. So if we talk about Korea, we talk about China, and that is where it happens. So because of some of these concessions, we see now the volumes also increasing. And once these volume increases, unfortunately also because of this 10% concession, there is a local company in India which is now suffering to say why these engines are coming at such low prices. Also, they have a duty benefit under the FTA. Now, what will you do? So there is a concept known as dumping. Now, dumping means a price of a particular engine which is being exported to India also is being sold in Japan, but in Japan when it is sold at a higher price as compared to the price when exported to India at a lower price as opposed to the price which is in Japan. Now, if this engine is coming to India at a price which is, suppose when I say 10% concession, so go on the basis that this product is coming to you much cheaper and then your cost of production, and then considering your reasonable profit which you could have earned otherwise, but given this concession and given that the voluminous imports are coming, your business is getting disrupted, you are losing your market share, you are losing your price advantage, and therefore even when the demand is increasing, you are losing your market. So this is where the parameters of injury come. There are three kinds of parameters, which is three types of injury. One is material injury, one is threat of injury, and the other is material retardation. Material retardation means you put up a new plant, you expected that within a year or two you will break even your business, you will be able to increase your market share, but unfortunately that is not happening. Causal link. This is a concept which says that injury is caused due to dumped imports. That means once you file the application or once you want any duties to be imposed, that injury which is being caused to you, the whole and sole reason should be the dumped imports and nothing else. And that is where the concept is of causal link. The WTO agreement, which is also the AD agreement, there is a comprehensive agreement of anti-dumping which is framed under the WTO. In India, under the customs tariff and the customs act, we have the same act and the rules prescribed. We have an anti-dumping provision under India, and that is where it is. Just to give you a little perspective of sectorial distribution of AD measures around the world. So 33% of anti-dumping measures today as it stands is on base metals and articles. So steel, aluminium, all those kinds of metals which we talk about. Then the largest next share is the chemical industry, which is 21%. Resins, plastics, articles, and rubbers are 13%. Machinery and electrical equipment is 7%. Textile and articles is 7%, and 19% is others. Now, in this others, we can think about telecom products. We can talk about components of many auto companies, auto parts. We can talk about many other products which today you may not get to see as a way the finished product or the intermediate product because of the nature of the product. So there are these 19% products which are on other side. As far as India is concerned, this is our distribution as far as the AD measures are concerned. So if the world was high on base metals, we are very high on chemical and allied industry. So that means all our chemical producers are in a way, have asked and requested the government and imposed anti-dumping duty almost on 45% of the pie as far as the AD measures are concerned. Resins and plastics and articles and all others is about 15%, textile is 10%, base metals is 10%, and 20% is all others. So this is as far as the distribution of India is concerned. Now, these are certain concepts under anti-dumping which is very important to understand, and whether today if you're an Indian company or tomorrow when you're competing with a Thailand company. So in a way tomorrow if you export to Thailand, what are the concepts which are equally applicable to whether it's a Thailand, whether it's a Korea or to India? These concepts remain the same because these are borrowed or followed under the WTO, and therefore these concepts are part of the AD agreement and therefore the domestic legislation. So we have to understand some of these, and I'll explain you some of them. Now, in order to bring an action for anti-dumping, you got to be a domestic industry. And who's a domestic industry? A domestic industry could be a company. A domestic industry can be a plus one more company. Domestic industry can be an association. And this is so. Now, one of the conditions of being a domestic industry is that you should manufacture the product which is actually being imported and competing with your product. So if you actually tell me you are producing a tractor and the import is coming off a car, so you want to put an action, that's not possible, because ultimately the product which is coming should be actually injuring you, and the product which is coming is being a dumped product from that other country which is hurting you. Those are certain conditions first which you need to fulfill. And there is that complexity of the product which I will take it in my next slide. So an applicant company should be a major factor for you to decide whether you have the authority to ask for a duty to be imposed. Now, the major proportion of the total domestic production, that is the indice. The indice is not capacity, the indice is not installed capacity, the indice is not sales. You should be producing minimum 25% of the total production of the same product within India. So if you are not, and if you're less than 25%, surely you have no right to file and ask for an action. But if you're more than 25%, if you're 25% and above, you should have no opposition to say from the rest of the 75 or 70 to say we don't want these duties. But if you are more than 50, surely nobody has a right to stop you to file or ask for these duties. Now, there are therefore a pie of three kinds of stakeholders. One is an applicant company, the guy who files the application. The other is a participating producer against duty. There are sometimes because of joint ventures, because of certain interests, or because of some people importing and exporting. So that is where it is. And then the last is the non-participating producer. That means the guys who do not agree to your coming, they just sit on the fence, and these are the guys who would say that you file the application, but we will support you from outside. So this is where these are the third kinds of stakeholders. Now, very quickly, like I said, it's interesting to understand the concept of product under consideration, because exactly this is the product on which you have a duty, which you want to impose a duty. Now, this, as far as concerned, the definition is very important, because ultimately, if you want a duty to be imposed, it has to be imposed on a particular product. And therefore, the product which has to be imposed has to be clearly defined. And that definition is very important, because until unless you have not defined or you have not explained the product, very important to put a duty on something. So I may say, okay, I know the tariff entry and I am happy to put the duty on the tariff entry. But tariff entry only explains the product but does not define the product. So it is very important to define the product. So taking again the example of an engine of a car, suppose if I say, I want to impose a duty on an auto engine. Okay, but if I say I can only produce 800 cc, but the tariff entry is under which both 800 and 1600 cc comes. So therefore, no, you will have to define the product. So the product will be defined in a manner which you can, A, you produce, B, that same product is coming into the country which is competing with you, and accordingly, the definition becomes important. And the test is the like article. And this is where it is important that the like product means an article which is identical or alike in all respects to the article under investigation for being dumped into India, or in the absence of such article, another article which, although not alike in all respects, has characteristics closely resembling those of the article under investigation. So now, taking an example here, again, suppose if I say a petrol engine or a diesel engine. Now, while my example will be very superfluous in order to say, oh, what is the difference between a petrol engine? I'm making petrol engine, but what is coming in is into the country as diesel engine. Now, can I say that this product is substitutable or no? Now, some people may agree with me, some people may disagree with me, but the test for deciding whether there is a like article or not a like article is this test, which is physical characteristics between the product, chemical characteristics, application and end use, cost to make and sell, price, applicable standard, production process, user perception, how does the user see whether a diesel engine or a petrol engine is the same, the customs classification. And accordingly, these are the indices on the basis of which we can discuss. This is something known as confidentiality. That means the information which you give as a domestic industry, how it is to be kept confidential. Of course, this information only stays with the government, because there are lots of information which you will have to give, and the information which comes from the other side. So suppose if you file a case against Korea and the Korean producers also want to give the data to show or to defend that they are not dumping or they are not injuring, that part of the information will also remain confidential. However, there are certain pieces of information which we can give, and that is where it is. Dumping. Now, like I said, what I explained to you was the concept. Now, these are certain numbers. So when I say normal value means that same product which is being sold in the originating country and just take for the example, television is Sony televisions are coming from Japan. So the normal value means the price of Sony television in Japan. And when I say export price means the price at which these Sony televisions by the same Japanese producer or exporter is being exported to India. Now, giving an example here that the product, if it is a TV which is sold at $100 by the exporter in home market, that means in Japan, and same product is sold by 80 in the importing country to India, that is what is dumping. So if $100, like I said, the product which is being exported to India is much lower priced at X factory as compared to the same television which is being sold by Japan, sold in Japan, accordingly the dumping is of $20. And the dumping margin you would calculate, and this is the duty which you would want to impose on any television which is coming from Japan. So you would say, I want at least a duty of 25%. Now, therefore, as a concept, dumping is important, and this is the slide for that. Now, let us explain what happens here. Now, there are situations where one is the domestic. That means when you look for a determination of normal value, that means price of the television in Japan, you would like to rely upon the same television being sold in Japan. But there could be certain situations when actually it may be very difficult to do that, because at the end of the day, there has to be a comparable price, a comparable market. And there could be situations like this. So let me tell you, from my experience, a lot of chemical clients in the Middle East, when we look at them, while they will actually fit the test of saying, yes, they produce in a particular country in Middle East. So suppose if I take the example of Bahrain, I will say, okay, there is sulfuric acid coming from Bahrain to India, and we want to file a case against them. But there are certain tests to see whether they are comparable or not comparable. And one of the tests is the volume test and the price test, which we usually see. And this is all prescribed and mandated as per the law, which is a volume test of 5%. That means once a product is coming to India, there should be minimum 5% sales of the same product in the originating or producing country. If the test fails, then, of course, Bahrain cannot be the comparable country for me to do the dumping exercise. Therefore, the law suggests either I can take and export to third country. So that means if Bahrain is exporting the same product from there to Indonesia, say again, the whereabout of 1,000 metric tons which is coming to India, can I take Indonesia? Yes, I can take, of course, Indonesia. I can take any countries which I like as far as possible. They are comparable, they are voluminous, and that's the point. Or if that's not being the case, the last alternative, so alternative to exports to third countries or cost to make and sell. And as far as the cost to make and sell is concerned, I will try and see whether what is the cost to make and sell of this acid in Bahrain, and take that as the benchmark price for the purposes of doing my normal value calculation and comparing it with the export price in India. So these are the tests. There is also a test known as 80-20 test. That means, suppose in Bahrain, when that producer is selling the acid in Bahrain, maybe we are expecting that all his products, what he sells in Bahrain, are all above cost. But there could be situations that in Bahrain, he is actually selling at a loss. Now, what could be those percentages? Whether it could be 80% sales or 20% are only profitable. Depending on that, there are certain nuances which you will take into consideration for the purposes of calculation, and you will only take those sales which are profitable sales and arrive at the normal value. And these are certain concepts in order for you to derive a price for the purposes of comparability. So there is also a concept of normal value for non-market countries. You must be reading in the press. One of the first problems, fortunately by America or the European Union has been against China being a non-market economy, because as far as the country is concerned, they are getting certain benefits, and therefore they are clearly working under the governmental interference as far as the banking is concerned, as far as the land is concerned, as far as the capital is concerned, all the subsidies are concerned. So therefore, these markets actually do not operate freely. So therefore, they are known as a non-market economy. Right now, of course, this whole debate against China is there. It still sort of stays strong. There have been, of course, certain cases under the WTO, which was supposed to be taken care of. But as far as the normal value for working out for a country like China is concerned, since they are not working under market economy principles, you can therefore take a surrogate country. So you can say, okay, China is not the best market. Now, which is the most comparable market? So suppose if it would be a chemical product, I would say, let's take Korea, or let's take Japan, or let's take Indonesia or Vietnam. These are certain comparable markets of for the purposes of arriving at the normal value and the cost. So I will rely upon that. This is as far as possible certain expenses which I will reduce in order to calculate the export price. One is, of course, the producer expenses, resellers and traders, and profit and expenses, price to the Indian buyer, and the first independent sale price. Now, actually, if I can start from country of export of origin and see exactly what is the channel of shipment, because there are sometimes producers who directly export to India. There are sometimes producers who use trading companies. There are sometimes producers may export directly but use another two countries for the purposes of invoicing. All these people are in the export chain, very important, and all the calculations in order to arrive at the export price is to be made and considered. Very quickly on material injury. Now, this injury is nothing but actually the grouse of the domestic industry, and in order to assess what is the injury, where is the injury, it is analyzed in terms of volume effect and price effect of the dumped imports. So that means those televisions coming to India on the domestic industry. So suppose there is a producer in India who's facing this problem, this is where injury will be assessed. Further, the effect of dumped imports on economic parameters of domestic also determined. Now, what are the volume effects? Like I said, volume effects are nothing but production of the domestic industry, capacity of the domestic industry, market share, import volume. How much does he come in? How much imports do they come into this market and disturb me? Those are the volume effect factors. Price effect, basically my cost to make and sell and my sales realization. What is my profit? What is my loss? Price undercutting, price underselling, price suppression, price depression. These are certain concepts which I take into consideration. There are certain other parameters which also are considered, such as sales volume, inventories, number of employees' wages, return on investments, and ability to raise. And finally, I calculate an injury margin. So the same way, when I calculated the dumping margin, I have to now calculate the injury margin. Injury margin, as far as possible, my costing friends and marketing friends are concerned, at least in India, if they ever want to bring an anti-dumping, it's very easy, very simple, because in India, based on our accounting principles and costing principles, and given the interest rates at one time when they used to be very high, so the government of India has established a return of 22% return on capital employed, which is acceptable for you to decide whether actually the imports coming, do they injure your profit line or your bottom line. Now, in India, when we calculate the non-injurious price, we take the cost of raw materials and utilities, overhead, SG&A, cost of production, cost to make and sell, and on all of that, then we work out 22% return on capital employed, which is known as the non-injurious price. This non-injurious price is nothing but a fair selling price, which you should expect based on your operations in India. This is the landed price. What is the landed price? The CIF price, customs duty, sorry, educational cess, and ultimately the landed price, which is payable to you. The differential between a fair selling price and the landed price is known as the injury margin. So take this example, 110, 100, and therefore the injury margin is 10%. Yeah. And as far as India is concerned, we follow something known as a principle of a lesser duty rule. So when I take into consideration the lesser duty rule, many jurisdictions such as United States, Brazil, do not look at the dumping margin or the injury margin, whichever is lower. So now, if you remember the example where I had calculated a dumping margin of 25%, and where I had calculated an injury margin of 10%. So India will go ahead and recommend only a duty of 10% and not to the highest level of 25%. But in United States, they would have done exactly of 25%. So this is known as a lesser duty rule concept. Coming back, like I had explained, there is something known as threat of material injury. Now, this is where we say a significant rate of increase of dumped imports have come. There is clearly a sufficient disposable capacities available in the market, or the imports are coming at a significant depressing and a suppressing market, and the inventories also are very high, and that is what it is happening now. Of late, because of COVID, we are getting a lot of queries, specifically against countries like China and many other countries, where we see suddenly, because the demand in every geography has gone out of proportion, which nobody had expected. Now, the Indian industry expects that suddenly all these imports will come to India. Now, in order to base that, there has to be certain credible evidence available, and accordingly, you can file these cases on the basis of threats. Like I said, causal link, which is very important. And as far as the causal link is concerned, we have to show that there is a clear and a direct correlation between the product being dumped. That means Japan is exporting at a lower price to India as compared to its own country. Injury. That means the domestic industry needs to show that because of these imports coming into the country, there is an injury, and this is the link. There could be certain other factors of non-attribution. That means apart from dumping, there could be a concept where the raw material supply is a problem in the country, where you are actually not getting a raw material, therefore there is more injury, or there are infrastructure and logistical hurdles to you, which is why your cost is very high, or there are plant shutdowns, or there are strikes, or there is a natural calamity. Now, these kinds of things cannot be reason for you to go and ask for duties, and therefore the factors of non-attribution are also assessed while considering these. Very quickly, coming to the end, the duty are imposed for a period of 5 years. Now, if the duty is going to be imposed for 5 years, that's a long period. Now, there are certain other instruments or mechanisms given under the WTO, where if it is a sunset review, that means before the expiry of the 5th year, you can actually go back to the authority or to the regulator to say that I would like to extend my duty for another 5 years. And there are certain countries and certain products where we've seen duties being imposed for a period of almost 20-25 years. We are doing, in fact, investigating one of the products right now, where the duty has been almost there for almost 20 years, and we are still seeing the effects of the injury being felt by the domestic industry. So there are, this is where the sunset review comes in. The midterm review is that before the, between the 2nd year and the 4th year, you may come back and say, actually the markets have now, bounced back. There is no injury to the domestic industry, or the dumping has now stopped, or the producer who was in that country has certainly shut down. So there is no meaning now to impose these duties. Now, that could be one argument if he's a producer and an exporter. But if you're a domestic guy, you can say, oh, ultimately I decided to put duties on which were earlier recommended or imposed at 10%. Now, according to me, the injury is now become higher, which is almost 30%. Now I want to file a case against this guy to increase my duties. So that is a concept where the midterm review comes. And last but not the least, the concept of a new shipper. Basically, this is one of the producers who was not around in the market at the time when the duties were there. So does it mean that he only now will have to wait after the expiry of 5 years duty? No. There is a concept of new shipper where a new producer can enter the market. He will have to self-assess that actually he would like to export the product and consider his own margin rather than a margin being put on him, and ultimately he needs to keep on paying for the remainder period of the duty, and that is where this comes. These are certain concepts under the sunset and midterm, which is self-readable, and I will not sort of dwell in this, but some of the concepts which are considered, particularly the likelihood of continuation or recurrence, that these are the reasons why you would like to ask for an increase. Those are some which we have highlighted here. Now, coming back, like we had said, anti-dumping as far as India's free trade agreements are concerned, as far as possible on the Indo-Nepal, there is no mention of anti-dumping. India, Sri Lanka, there is some mention about how we will, as far as possible, the rights of the party in an anti-dumping. So, like I said, of course, you can use this instrument under the WTO, but there are sometimes certain carve-outs which countries may do between each other, that when they actually negotiate an anti-dumping. So in India, like we have the Indo-Korea. Now here we have certain detailed provisions, like before we initiate, we will inform the Korean authorities that we are going to be initiating a case against you. We will also go ahead and give them a sort of a hearing to them, which is between government to government to address these issues, that what can we do about it. So these are certain rights which are given to member countries of the FTA or the RTA between themselves as to how these issues are going to sort of remain. So these are certain obligations which you give, like notification of the petition, application of the lesser duty rule, prohibition of zeroing, exemption from new investigation within 1 year after termination. So suppose, in a review investigation, we complete within 3 years, and after that, again, the domestic industry comes back and says, no, again, I want a duty. So, you will give some relaxation between countries, and that is what the understanding is. So, this is where my presentation part ends as far as an anti-dumping is concerned. I'm happy to take any questions which you may have and take it from there. After this, I will request my colleague Parthasarathy Jha to take the anti-subsidy or the CVD measure, followed by Amrish Satyanathan as far as possible on the safeguard, and take it from there. These are different instruments, like I said, and these are the nuances under each of them.
Thank you. So I have given the presentation.
So
to take the question, one question is the same.
I'm happy to also take your questions at the end, but in case if you'll have any other questions by the time Parth loads his presentation, happy to take it from there.
Sure. Then I would request Mr. Parthasarathy to do the presentation.
Sorry, your voice is not clear.
So we can request Mr. Parthasarathy to do the presentation now.
Yeah, sure. Okay, thank you.
Thank you. Parthasarathy, can you make the presentation now? I given
Can you hear me? Sorry. Am I audible?
Yeah.
Great. Oh, thank you, Ms. Vishnupriya and the CI team. Thanks, Sanjay, for an elaborate description on the trade remedial measures and FTA. That makes my job much easier. So I would be discussing anti-subsidy measures here, which is also a part or a kind of trade remedial measure. Sanjay has already given details of how FTAs work. The good thing is that there are a lot of commonalities between anti-subsidy measures and anti-dumping measures in terms of process and procedure. So I'll be skipping those parts and quickly take you through my presentation. Yeah. So first, if you're able to view the screen, anti-subsidy measures, as far as India is concerned, there has been very few cases. Traditionally, India has only focused on anti-dumping measures, although the rules have been there for some time since 1995. But anti-subsidy measures, unlike other countries, if you look at United States or European Union, typically every trade remedy investigation which they do, there will be simultaneous investigation on anti-dumping and anti-subsidy. But India, for some reason, has not been a great user of anti-subsidy measures, but the trends are changing, and it's likely to change even more considering the COVID-19 impact. And as we all know that during the COVID-19, almost every government which we can think of in this planet has provided some or the other, or continues to provide some or the other sort of financial support or packages or tax credits, all of those things. And therefore, this period is going to see more cases on subsidies because every country would like to countervail the subsidies offered by the other country. So that's to begin with. Now, why are we discussing what we are discussing? That's also very important. Like Sanjay said in the very beginning of his presentation, that any trade remedial investigation, whether it is inbound or outbound, to the extent if you are an exporter and if a trade remedial investigation is targeted at you, it is going to impact your business. In some cases, it may impact your business in a manner that the entire market can be closed, in the sense that the duties will be so high that practically it is impossible for you to participate in that market now and tap any market share. So it becomes very important in most cases to see what the product they are investigating, what kind of injury margin or subsidy margin has been framed, and whether a participation is worth or not. If you don't participate, or non-participation, like anti-dumping law, results in very high duty margins, which are almost penal in nature. Uh, this slide is very clear. Like I said, measures in India have been very less than 10 measures. You can say the ongoing investigations are also quite few, again less than 10. If you look at where India has been positioned vis-a-vis world, most cases against India, United States and European Union take the lead. US is the most aggressive user of trade remedy measures against some of the developing economies, including India. So here you can see that. So in terms of an outbound sort of businesses which are going outside India, exports, US, European Union, which is one of the key markets for India. I know we are going to discuss FTAs subsequently, but that's very important that US and EU is one of the aggressive users of anti-subsidy measures as well, and India has been party to many of these investigations. Uh, Sectoral distribution, if you look at all WTO members, base metals almost take the 50% of the pie. Chemicals is also very significant, 10%. Resin plastics is significant, but metals are, of course, steel, aluminum. These are very sensitive products, so these have been always been target of trade remedial measures. Within India, if you look at India's case is not very different. If you look at base metals and articles, again 43%. If you look at chemical, 29%. So it goes similar to the world trends where you can see 50% for base metals is there. Now let's understand the law. So anti-subsidy agreement or the subsidy measures to begin with, it's important to understand what subsidies are. And before I get into that, let's understand what are the rules and regulations which apply. So essentially, we are talking about, from an India perspective, if you look at two sets of legal or a legal text. One is the WTO agreement on SCM agreement, and second is the domestic law of India, which is basically captured under Customs Tariff Act, and there are rules therein as far as India is concerned. So similar to India, other FTA partners of India, they would also have similar domestic laws, because every party who is member WTO, he has liberty to come out with their own domestic set of laws which conform
to the WTO agreement. They don't go against the WTO agreement. The entire measure has to be in line with what WTO agreement provides. Now let's understand what is a subsidy to begin with, essentially. So subsidy is nothing but it's a sum of financial contribution and benefit. There has to be a financial contribution by a government or a public body, and that financial contribution must result in some sort of benefit. It doesn't matter whom you are giving it did not necessarily be to a particular person. You can, so long there is a financial contribution by government and there is a benefit conferred on any recipient, you will say that a subsidy, the definition of subsidy is complete, a subsidy exists. Now what is financial contribution? A financial contribution could be in the form of direct cash payments or direct, say, equity investments. It could be in the form of, say, loans. Similarly, financial contribution could be in form of tax breaks, tax credits. If you are providing any sort of tax remission, refund, so any sort of tax breaks which otherwise you would have been liable to pay tax, and if the government is providing you any relief on that, that is a financial contribution. Financial contribution also means if government is providing you goods and services at less than adequate normal value, or in the reverse, if it is purchasing goods and services from you at a very higher price, more than market price, so then it is giving you some sort of financial contribution. And all of this need not necessarily be always from the government. Government can entrust a private body, which is a purely private actor, and ask the private actor to do these things. That will also fall within the definition of financial contribution. And if this financial contribution leads to a benefit, you call it a subsidy. Now, are all subsidies problematic from SCM agreement perspective, the agreement on subsidies and countervailing measures? The answer is no. We are concerned with only those subsidies which are specific subsidy, and there is an economic reason to that. If a subsidy is widely available in an economy, in the sense that anyone and everyone can get it, it is not specific to an enterprise, the impact of this is completely neutralized. But if it is a specific subsidy to certain enterprises, or to say a industry or a group of industry, or designated for a particular geographic region, so long there is any specificity, SCM agreement is concerned with that. If it is not a specific subsidy, there is no case. However, in most cases, I mean, this is only an academic point, it's very difficult to argue in cases that a subsidy is not a specific subsidy. Generally, typically, I would say more than 95% of case, a subsidy is generally designed in a manner that it will fall into the definition of specificity. Now, under the SCM agreement, there are two kinds of subsidies. I'll quickly take you through. One is a prohibited subsidy, other is actionable subsidy. When the SCM agreement was formulated back in 1995, there was something called non-actionable subsidy, but that was only for a certain defined period. That provision has lapsed. Of course, WTO is talking about reform in subsidy disciplines, and today again those talks of classifying certain kinds of subsidies as non-actionable subsidies, those kinds of discussions are happening, but we don't know where it will go. But essentially today we have something called prohibited subsidy, and we have something called actionable subsidy. Now, what is prohibited subsidy? Essentially, there are two kinds. Subsidies which are either contingent on export performance, or subsidies which are contingent on use of domestic goods over imported goods. These two kinds of subsidies are prohibited. So, for example, let's take India's case. India has this export of capital goods scheme, EPCG scheme. Basically, it tells you that if you if you fulfill your export obligation, the capital goods which you have imported, it will be duty free. So one can argue that the fact that the capital goods are duty free, so there is a tax break, it's a financial contribution, it is offering you a benefit because you are not paying that much amount of money to the government. And the fact that you're getting this import free is contingent on the fact that you meet your export obligation. So it is contingent on your export performance. So therefore, it is a prohibited export. Similarly, local content could be a simple example of that would be that if the government tells that if you utilize, say, domestically manufactured lithium in producing your electric vehicle, I will provide you a certain amount of money, or I will give you some sort of tax break. That will be again a prohibited subsidy because it is contingent upon the fact that you utilize something which is domestically manufactured as opposed to imported. Accidental subsidies are all other kinds of subsidies. Anything which is not a prohibited subsidy, it is actionable. Now, in context of trade remedial measures, a government can take action or a countervailing investigation on a countervailing action against both kinds of subsidies. If it is a prohibited subsidy, it can take a countervailing action against that and impose a countervailing duty. If it is actionable, it can do that. Now, what is not a prohibited export subsidy? And this is very important to understand in context of India's export policy. The mere fact that something is contingent on export always doesn't qualify as a prohibited export subsidy. There is a footnote in the SCM agreement which recognizes the fundamental principle that taxes should not be exported, because in any case, what the goods which you are exporting in whatever country it is going, that those goods will be taxed. So don't export your taxes. So to the extent the taxes should not be exported, the WTO agreement recognizes this as a principle, as an excess remission principle. And all it says, this whole slide which you are looking at, is that if you are remitting or exempting tax on an exported product, which is not in excess of duties or taxes which are levied on the like products for domestic consumption, then it is not a prohibited export subsidy. So in other words, if I have, say, if I am producing a product, say P, and there is, say, 10% duty on P in for domestic consumption, and I do not levy that 10% of duty on the export of the same product while they are manufacturing it and producing it outside and exporting it out, this exemption of 10% duty on P should not be considered as an export subsidy, because it is not in excess of what is being provided in the domestic. Had I done more than this to any other manner, then that excess is something which becomes contravailable or prohibited. Now, this footnote has been explained in more details in Annex 1 of the SCM agreement. It has been also incorporated under India's own CVD rules, and that's very technical. But to simplify it and sum it up is essentially this. If you are importing any input and you are utilizing that input to produce a product which you will export, and if the government gives you an exemption of, say, import duty on that input because you are going to use it for an exported product, to the extent that is not more than what the product which you exported, had that product been destined for domestic consumption, then it is fine. It's not a prohibited subsidy. Take example of advance authorization scheme which India has, right? In advance authorization, what do? We import some inputs, we'll utilize it to manufacture a goods which will be exported out. Of course, there are SION norms and all of that. So this is something where we are importing an input and there is a, say, exemption on payment of import duty because that input is going to be utilized in manufacturing of goods which are going to be exported. This is something which the SCM agreement and our rules say that to the extent this is not in excess, you are fine, we can do it. Similarly, if there are indirect taxes remission, so import duty is not an indirect tax, it's a border tax. But say if there are indirect tax remissions on goods or services which are utilized for a product to be exported out, to the extent such remission is not in excess of the same goods when destined for domestic consumption, those indirect tax remissions are fine. It need not be classified as financial contribution. So essentially, that's what Annex 1 talks about. There are other examples in Annex 1, but this is a carve out, and this carve out is not just in itself. There are other conditions attached to it. There are Annex 2 and Annex 3 to it. You'll have to show that you have a verification mechanism, that you are not remitting or giving exemptions of more than what is required in excess of, because one has to show that there has not been an excess remission or exemption of tax. And for that, you need a verification mechanism. Government would need that. And that becomes very important in case of countervailing subsidy investigation. And I'll come to that separately during subsequently as part of my presentation here. Now, Anti-subsidy measures, if you look at, typically India has been subjected to, when it comes to subsidy measures, some of its central schemes and some of its state schemes. If we talk about central schemes, most of these schemes are flowing from our FTP, foreign trade policy, some outside FTP, or most of them are FTP. So SEZ and all is not part of foreign trade policy. You have a separate act for that. You have custom duty drawback rules, which is part of separately under customs law. But under the FTP, you have all these EPCG, advanced authorization, DFIA, export-oriented units, EOUs, and all of that. That's bulk of the FTP at central level. Again, at state level, there are subsidy programs which have been controversial. Mostly, it has been state of Maharashtra, Gujarat, and Tamil Nadu, because much of the exports or manufacturing is happening in these states. So they have been mostly target of anti-subsidy investigations by United States and European Union. Now, I'll quickly take you through where we stand on all of these schemes. The fundamental principle, as I said, is that to the extent there is a financial contribution, which could be in the form of cash payments, loans, equity infusions, or tax breaks, or any other thing, provision of goods and services. To the extent there is any financial contribution and it confers benefit, it will become a subsidy. Now, if you look at all these schemes, advance authorization, duty drawback, export, promotion, capital goods, yes, there is a financial contribution. You are making payment, you are exempting tax, so there is a financial contribution. Of course, it is benefiting you, so it's a subsidy. But is it a subsidy given the exception which the CM has created, that if the remission in these cases where the subsidy is designed in a manner that it is targeted at inputs for utilization of exported products and all, can it be called as a subsidy? The answer is technically no. But has India been contravened? Answer is yes. India has been contravened on these schemes like advance authorization, duty drawback scheme multiple times by United States and European Union on the ground that India does not have a verification mechanism to show that there is no excess remission. And this is flowing from Annex 2 of the SCM agreement. It is also part of India's laws. It's part of all other major countries who have their domestic regime on subsidy. They have the principles adopted. Now the question is that what they have been subjected to is that what is, I mean, has United States and European Union been fair in its processes when it has subjected AAS and similar other schemes to countervailing duty? And answer seems to be no, because of the I would say a couple of years back there was a decision from panel which also went to the appellate body, and it was confirmed wherein Pakistan took up against European Union a very similar program of Pakistan which was countervailed on this very same ground. There was no verification mechanism. And the panel also, as confirmed by the appellate body, said that, oh, you can't do that. If you think that there is no verification mechanism, you are duty bound to take some additional steps. You look at the enterprise when you are investigating, the company you are investigating, see whether there is any excess remission or not. They have provided you all records. You can't simply go and countervail everything. If there is something excess, you should do that. So you have failed in your duty. I mean, very interestingly, when US or mostly US, when they countervail AS, they don't even look at the excess. In fact, the entire duty amount which you have saved from under advance authorization, they countervail. Now, so this is something which India needs to take a strong position on this. At some point of time, perhaps if it continues, India may have to challenge it at the WTO, which is something which I can't comment on, but this is something which is a problem. All such schemes are being countervailed by these countries. Now, if we come at EPCG and certain other schemes like UOU, MEIS, and SEZ, all of these schemes have been subject of a very recent dispute between India and United States. They have been countervailed in past, left, right, and center. But recently, United States filed a dispute in WTO saying that these are prohibited subsidies the government of India should not have maintained to begin with. And unfortunately, India lost this case. Partially, I would say. In some aspects, we didn't. In some aspects, we did. So if you look at EPCG scheme, the fact is that EPCG scheme is a benefit contingent, benefit connected to or attached to capital goods. And panel's position is that capital goods is not an input. Input is something which is utilized or consumed during the process of production, and capital goods doesn't fall into that. So therefore, whatever benefit we are giving there, we don't fall under that exception. and therefore it is countervailable. Under UU and all, to the extent there is no excess remission, panel found it is fine. But to the extent you are not because UU's provisions are very wide, and to the extent it goes beyond inputs, this is prohibited subsidy. Similarly, MEIS was attached fully to exports. If you export certain specified tariff lines into certain specified markets based on the value of the export value of the goods, you get certain scripts, 2%, 3%, whatever. And that script you can utilize for tax payments. You can adjust it for customs duty payment in future. It has, of course, a time period and all of that. But it was essentially flowing out from your export. And that was held by the panel to be prohibited subsidy, can't maintain. As you will be aware, in between there were talks that it will be removed. However, the recent media reports say that it is going to be continued, and the government has also simultaneously come out with something called road tape. And road tape, to the extent it tries to neutralize or it tries to provide credit on all the non-creditable taxes, and to the extent road tape can satisfy that it has verification mechanism, can be a good measure. So that's, of course, very recent. You would be aware of that. The special economic zones, again, special economic zones contains all kinds of duty benefits, not only on imported inputs, but capital goods and all of that. So to the extent there are exemptions on inputs, that is fine. SEZ shouldn't have a problem, but anything beyond that, the panels are held to be inconsistent. Now, and all of these have been countervailed by different countries, particularly United States and European Union in the past. As far as Maharashtra, Gujarat, and other state schemes are concerned, if you look at the state schemes, typically it will have all these. Typically, you will have all these schemes which will have provisions like, exemption on reduction on electricity duty or utility, or some sort of reduction of stamp duty, state level taxes. Then you will have government will, to attract investment, they will say that I will provide you land at less than a market value. So many permutation combinations, and these are all come in a package sort of scheme for attracting investment into particular state. And the fundamental line is this: if the government is providing you anything beyond, in the sense that it is providing you any sort of, say, benefits in terms of reduction in taxes, or it's providing you loan at, say, less than market interest rate, or providing you land at less than market rate, all of this will be considered as a subsidy, because this is a financial contribution and you're getting benefit, and they are countervailed routinely. So that's the fundamental principle here. Now, I quickly take you through the anti-subsidy measures and procedure. This is very similar to anti-dumping law. You need to have an initiation, and initiation should show that there is a imports of subsidized goods, which is causing injury to the domestic industry, and similar timelines, 1.5 years at most, 5-year period within which you can have reviews and all of that. It is also country specific, like anti-dumping law. So not much difference. The only difference is that before initiating a subsidy investigation, you should have a consultation with the partner countries at government to government level. Same concepts of domestic industry, product under consideration, confidentiality, no differences. The only difference here, I would say, is that instead of dumping, you looked at subsidization. Injury parameters are same. You assess the injury in the same manner, causal link in the same manner. As far as lesser duty rule is concerned, of course, there is lesser duty rule here as well. But lesser duty rule automatically also incorporates in itself the concept of injury margin. And concept of injury margin incorporates in itself the concept of non-injurious price. Now, unlike anti-dumping law, you don't have a set of rules under SCM, the CVD rules in India, that how do you calculate your NIP. But practice of the DGTR has been that they calculate NIP based on the same AD rules, where they will normalize inefficiencies and calculate a fair selling price for the domestic industry, and based on that they will do. Threat of material injury is again very similar to the anti-dumping law. Instead of dumped goods, you look at the subsidized goods, but parameters are same. Review is also same. You have something called a midterm review, which you can do anytime between, say, 2nd to 4th year. Anytime after 4th year, you can do a sunset review, and a newspaper review can also happen anytime before the sunset review. the standards are also pretty similar. The only difference is that there you look at, like in a sunset review, look at likelihood of continuation, likelihood of continuance or recurrence of dumping or injury. Here you look at subsidization and injury. So that's the difference, but otherwise the parameters are same in terms of review, that how do you take your decisions with respect to varying your duties or removing or withdrawing your duties in a midterm review or a sunset review. Calculation of subsidy margin. Well, this is very different than calculation of dumping margin. In dumping margin, as you just heard, that there is this concept of normal value and export price, and you take a difference of that. That's not relevant here. All you need to do is that you need to find out what is the subsidy which the government has given, and in order to calculate the margin, you need to have a denominator. And depending upon the nature of the benefit, the denominator may change. So, for example, if it is export subsidies, contingent on export, the denominator would be the value of the total exported products and not all products which you have sold in the PI. So if it is a MEIS, and if you have say been given say 100 crores as a in terms of duty script, and in the same period if you exported out say 1,000 crores of goods of value, so your subsidy margin would be calculated as 100 by 1,000, which is 0.1. So that's your subsidy margin in terms of percentage. Depending upon if it is a non-export subsidies, then they will take into account both the domestic and exported goods, the total sales of value of your particular, I mean, the product in this consideration, and on that basis they will calculate. So it becomes complex in each case, depending upon when you talk about capital goods, where you need to look at the average useful period and you need to calculate depreciation and all of that. I'm not getting into that. Those are fact specific right now. But yes, I mean, there are rules and there are practices on how do you calculate subsidy amount, and thereafter how do you calculate subsidy margin. This is the example which I just spoke with you, which is about the MEI scheme. Then anti-subsidy measures under FTAs. So like anti-dumping and safeguard measures, not many FTAs which India has entered into have detailed rules on SCM on subsidy measures, but all of them rely and they do state that their rights under the WTO remain intact. So in any case, WTO has a detailed agreement, like I said, and there's nothing very peculiar in India's FTAs with respect to SCM agreement. Unfortunately, India has not been a great user of subsidy measures in past, but likely in future that we can see more subsidy investigations, including countries which are FTA partners. There is no concept of bilateral anti-subsidy measure. The subsidy measure will be generally against all countries who are found to be subsidizing goods, have exports above or imports into India above de minimis. They all will be subject to that. Now, just a few points before I finish. On outbound, I also understand that you may be interested in exports, particularly with these FTA countries. Now, there is limited information available, but some of these countries, Vietnam, Indonesia, Korea, they have various kinds of schemes which have been challenged before, say, United States and EU, where these are some of the examples where they have targeted these subsidy programs and contravened it. So when you are exporting some goods into this country, or when you are reverse actually, when you are importing goods, when goods are being imported from these countries into India, and if there is a domestic industry, it's a fair indication to them that how some of these schemes are operating in these FTA partner countries. And if you're injured as a domestic industry, you can always take appropriate action. That's where I will end my presentation, and I will be happy to take any questions which you may have at this point in time. Hello?
Thank you.
Hi, Vishnupriya, are you there?
Hi. Am I audible?
Yeah, I hope I was audible.
Yeah, you were audible.
Yeah.
So thank you for the presentation. Would you like to take your questions now or at the end?
I'm happy to take any questions right now if they have. Otherwise, I can take questions along with Sanjay at the end as well.
Yeah, if you can take it at the end, we'll have more
Sure,
questions.
that should be fine. So may I now invite my colleague Amrish Satyanathan, who is speaking on safeguard measures.
Okay. Yeah, I'm just giving him the presentation. Right.
Thank you very much.
Welcome for the presentation. Please continue. Thank you.
Okay, thank you, Vishnupriya, thank you, Parth. Is the presentation visible to everyone?
Yes, it is visible.
Okay, fantastic. So I'll get started. Thank you, Parth. Thank you, Vishnupriya. Good afternoon, everyone. My name is Ambarish Satyanathan. I'll be taking you through the next section of our presentation. We will now be discussing safeguard measures. As always, we will take queries at the end of the presentation, but feel free to interject with your questions at any point, please. Let's keep this free flowing. All right, safeguard measures. There are two types of safeguard measures: global or general safeguards and bilateral safeguards. Global safeguards are levied under the WTO, while bilateral safeguards are levied under specific provisions of the trade agreements, which are usually signed by various countries. Out of the two, global safeguards are far more commonly used as a trade remedial tool, but both types of measures have significant overlap in terms of key concepts and prerequisites. We'll go over those. Let's take a look at global safeguards first, since they are more commonly used. Okay, global safeguard measures. Uh, Global safeguard measures have these characteristics which are on your screen. They are emergency actions, very important to keep in mind, and I will elaborate upon this later. They are usually against increased imports of a product, where such imports have. I'm sorry, is my screen interrupted by is this better? Is this interrupting? Is my screen fully visible now? Vishnupriya, can you hear me?
Yeah, it's fully.
Yes, we can hear you. Yeah.
Thank you. No, I just wanted to ensure because there was a window.
Yeah, you're clear, sir.
Perfect. Thank you. I'll carry on. Okay.
Thank you.
So yeah, so global safeguard measures. I'll just reiterate real quick. Emergency actions, which are usually against increased imports. These imports need to have caused some kind of injury to the domestic producers of the product, and their global safeguards, by definition, as you know, the word global indicates, are against all imports, except some exceptions made for developing or least developed countries. On your screen you can see the name of the official agreement under which these safeguards are implemented. We will of course come back and dig a little deeper into these parameters, but since you've just seen two very succinct presentations on anti-dumping and anti-subsidy measures by my colleagues, I think it might be a good idea to first assess exactly what is common and different between safeguards and anti-dumping and anti-subsidy measures, since that would be fresh in your mind right now. So that's what I'll go to next. Okay, so safeguards, overlaps and differences with AD and CVD. Some broad principle-based issues that are common between all three, with minor nuances, of course, are product scope and like article, which was explained in quite a bit of detail by Mr. Notani. Confidentiality requirements and causal link. These are all things that have been touched upon previously. Sanjay and Parth have respectively already explained these in impressive detail before me, so I'll not get into these again. But even more interesting are the differentiating factors here. First of all, safeguard measures are emergency measures, like I mentioned previously. Another way of calling them emergency measures is to call them no-fault measures, which you can see at the bottom of the screen there. Unlike anti-dumping or anti-subsidy cases, there is no need to establish in safeguard measures the existence of an unfair trade practice, so as to justify the levy of duties. Of course, due to this no-fault principle, the standard of injury, which is called serious injury, is much higher in safeguard cases compared to anti-dumping or anti-subsidy cases. Lastly, global or general safeguards target all countries, like we mentioned previously, while anti-dumping or anti-subsidy measures target very specific countries depending on where you can prove unfair trade and which are all the other corresponding prerequisites associated with volume and price. Having established how safeguard measures are unique, let's take a look at how India and the rest of the world have been levying safeguard measures, particularly in terms of sectoral distribution. This is interesting. Okay, I'll take a look at India first. So in India, there's a very peculiar scenario, and this will become clearer once we look at the global scenario. Because in India, a majority of cases is on chemical products. In fact, in the last 2 years, 5 out of 7 safeguard measures have been on chemical products only. Now, this distribution does not necessarily reflect a policy position of the government. Please bear that in mind. Some of these statistics actually reflect how well that particular industry may have been able to use safeguard measures for its protection. Okay, this, of course, that's also not the only factor, but that is one factor. This means that there is a vast scope of products in India where industries can similarly also protect their markets as long as they can meet the prerequisites for the levy of safeguard products. Especially in the current policy climate, I feel that's very relevant. Let's take a look at what globally has been happening. Okay, so globally also chemicals are clearly a large part of measures. You can see that 26% of sorry, 19% are chemicals. The largest share is, of course, to base metals at 26%, and then there are some other miscellaneous products that you might find which are levied with safeguard. Now that we've set some context here on how global sectoral trends are taking place and what are safeguard measures, let's dive back into the key concepts of a safeguard investigation. More specifically, what does an industry need to know to understand in order to pursue the levy of safeguard measures on its product? If a manufacturer is bothered by imports which are competing and hurting his market, what does he need to know before he approaches the authority for safeguard measures? Let's get into that. So, minor reiteration, a quick recap. We already saw this in a previous slide, but just since we're revisiting this, I'll bring it up again. Distilling the requirements of a safeguard investigation, simple. There needs to be an increase in imports due to unforeseen developments. There needs to be serious injury caused to the domestic industry. And there needs to be a causal link between this injury and the import behavior described in point number 1. This is, of course, a very simplified breakdown of what constitutes a convincing case for safeguard measures. Behind each of these parameters is a set of core concepts that drive any safeguard investigation. We'll get into that as well. Let's see that next. So on your screen right now are these core concepts. Any industry would need to have preparation and data available on these concepts in order to approach any authority for safeguard measures to be levied. We'll address all of these separately in the following slides. As I just mentioned, some parameters like product scope and confidentiality are common between anti-subsidy, anti-dumping, and safeguard. So I'll not be revisiting those in the interest of time, but we will certainly look at the unique parameters that occur here. So number 1, domestic industry. Large overlap with anti-dumping and anti-subsidy. So you already know some of the basics. The requirement on the surface seems very similar. There is one small but very crucial difference. You see, there is no specific prescription on a percentage requirement of total production in India for a company to be considered domestic industry. This stands out in stark contrast with AD or CVD, where there's a 25% requirement. Okay. So then how do they determine what major proportion is it? You can see to the right of your screen, major proportion of domestic production. Does it mean majority? Do I need to prove more than 50%? The answer is no. Authorities recently, as about 6 months ago, have recognized that as much as 38% of total production in India is also sufficient to constitute major proportion, as long as all the other requirements on your screen are also fulfilled. Namely, the one on your left, which says that if you're, say, 35% of Indian production, it should not be the case that 36% of Indian production or Indian producers are opposing the duty. As long as that condition is satisfied, even 35% of Indian production is considered sufficient for bringing a safeguard case. Okay, so let's move on to the next point, which is the core issue. This is the first assessment made in any safeguard investigation. Increased imports. Needless to say, any safeguard investigation would not succeed if the domestic industry cannot demonstrate that there is an increase in imports of the product being examined. In fact, simply proving an increase in imports is also not sufficient. As you can see on your screen, the increase must be in the recent period. It should have been sudden and abrupt enough. Should reflect a sharp and significant increase in quantities. Let's take an example. So you have an example at the bottom of your screen right now, which is the optical fiber case. The DGTR found that the increase in imports between 17-18 and 2018-19 was over 200% or 200 index points, taking base as 16-17. This was considered recent enough because it was just in 18-19. It was considered sharp enough because there's a 200% increase, and it was considered significant enough because that's a huge jump in quantities also. You see in the second last row, you have a jump of about 4,500 tons. So the DGTR found this to be significant. Of course, other parameters were also found to be positive, and therefore they recommended the levy of provisional duties. Now, this does not mean that in every case the increase in imports has to be 200%. Let's bear that in mind also. One would need to assess each case and each industry, each product separately, since market behavior and import trends would vary from case to case. Now, given that these are emergency measures, there's another requirement for increase. Let's see what that is. Unforeseen developments. This is a unique feature of safeguards. You'll not see this as anti-dumping or anti-subsidy. The increase in imports, which is proved, as per our recent slides, to be sudden, recent, sharp, and significant enough, must also be caused by factors that were unforeseeable. In other words, if India wants to levy a safeguard duty on increased imports on, say, televisions, the Indian DGTR must first assess that the increase in imports was caused due to factors that India or the Indian industry could not have reasonably predicted. there is always a lot of subjectivity on how this unpredictability is interpreted by the authorities around the world. So, again, there's a factor of, subjectivity in terms of circumstances of each individual case and industry. But this is the general requirement that you can see. Globally, under the WTO case law, there are various standards set for it, which are also on your screen. All right. So now that we've seen what is required to be established in terms of increased imports, let's take a look at what needs to be established next. What's the next step? The next step is serious injury. Okay. Now, serious injury also has a lot of similarities with material injury. Material injury is the injury you saw recently in the slides presented by Sanjay and Parth. Many of the volume and price parameters are common, as you can see. This grid would have appeared in previous slides as well. Other parameters like capacity utilization, profit, return on capital employed, also common. One key differentiating factor is that, at the bottom right, there was injury margin in previous slides. There is no injury margin determined in safeguard cases. There is a straight determination of duty. Another major differentiating factor which we must bear in mind, especially if we are contemplating asking for safeguard duty as Indian manufacturers, is that serious injury has a higher standard of assessment, okay, compared to material injury. Now, what does higher standard mean? It is not easy to quantify that, frankly, but a simplified explanation would be something like this. If a bare minimum injury is considered to be sufficient for the levy of anti-subsidy or anti-dumping, the domestic industry would need to prove a higher injury than that for justifying safeguard levies. Anything more detailed than that for comparing these two would become subjective and would again depend from case to case. Another thing that we will not specifically cover here, because it's already been covered with regard to injuries, that is causal link. Just like in anti-dumping and anti-subsidy cases, a causal link needs to be established between serious injury and import behavior. But causal link and non-attribution factors have very impressively covered already by Mr. Notani, so I'll not get into that. Now we've covered increased imports, unforeseen developments, and serious injury, along with causal link. Now, there is one final requirement that any company would need to fulfill, apart from these, to make a strong case for the levy of safeguard measures. And that is the formulation and presentation of an adjustment plan. Okay. You may recall this phrase that I've used a couple of times now in this presentation, which is the no-fault measure. Safeguard is a no-fault or emergency measure. This means that there's no unfair trade required to be proved for safeguard measures to be levied. You see, when you're approaching the DGTR for a levy of safeguard duties, you're essentially telling them that, look, there is no actual unfair trade necessarily going on here. Okay, it is just a case of increased imports from which I, as an Indian producer, hypothetically, need temporary and emergency protection. Now, the law requires that while doing this, it is important that you convince the DGTR in India or the authority wherever you are that if such duties are levied, you will take positive steps to adjust your company's operations in such a manner that you are able to compete with the imports once the duties are removed. The adjustment plan, so for example, the adjustment plan could be something like optimization of plant and machinery, more efficient utilization of plant or machinery, some kind of vertical integration, to reduce raw material cost, or other such measures taken to improve efficiency of operations. This is particularly levied strictly in India, but globally, it's not a mandatory requirement, as you can see in the first point on your slide. Under Indian law, it's almost always assessed with very few exceptions. So the Indian authority will almost always see this. This is again dependent on facts and circumstances of each product or industry. Okay, so now what next? We've now proved that there are increased imports, there is serious injury, there's a causal link. We've provided a coherent adjustment plan and convinced the DGTR to levy safeguard measures. Exactly how are these measures levied? Let's take a look at that next. Okay, so levying global safeguard measures. Once it's determined that there's a case for a levy of duty, the authority may levy the measure as a quantitative restriction or a duty, as you can see on your slide. Duties can be either ad valorem, which is a percentage of import price, or duties can be a fixed form, which is a fixed per ton or per unit rate of duty, so $20 per ton, or a reference price, which is basically a benchmark price. So you set a $100 price, suppose, and if the imports come at $80, the duty will be equal to 100 minus 80, which is $20. So these are the three mainly used forms of duties. In safeguard, almost always there is an ad valorem rate applied. Okay, when the duty form of safeguard measures is used. Okay, as far as quantitative restrictions go, which is the other type of measure, these are basically quotas determined for import quantities. If such quotas are breached, appropriate measures or duties may be levied on such excess imports. India has historically actually levied only safeguard duties. They have not levied safeguard measures in terms of quantitative restriction. However, in recent times, a few initiations are taking place on quantitative restrictions as well. So the DGTR and the Indian authority and government are clearly also entertaining applications for quantitative restriction if the requirements are met. Apart from the forms of duty, these measures must be applied on the product irrespective of source. We already agreed to that or covered that, where global safeguard measures cover imports from everywhere except some developing countries. Safeguard which are longer than a year must be are required to be progressively liberalized. So for example, if you levy duty for at 20% in the first year, in the second year you should recommend a smaller rate of duty, so 15%, and then in the next year after that it should be 10%. As per Indian law, duties can be enforced for a maximum of 4 years, and then you can renew them by way of a review. Okay, but even then you can't keep renewing them ad infinitum. You have to stop at 10 years. Okay, even that 10-year timeline is usually never reached in India. In India, duties usually don't go beyond 2 or 3 years, except for a very few exceptions. All right, we've now spent some time going over general safeguard measures. And you'll recall that there is a second genus of safeguard measures which we discussed in the beginning, which is bilateral safeguards. Before we dig into the specifics of bilateral safeguards, since we've just discussed global safeguards and this is fresh, let's take a quick comparison and contrast between general safeguards and bilateral safeguards. Okay, two main points of difference that you can see on your screens here. One is, so there are the two main questions here, which is one, who are the target countries? Okay, which are the target countries for global safeguards and bilateral safeguards? Question number two, what is the nature of relief granted? These are the two main differentiating factors. In global safeguards, all countries are targeted, like we've seen several times. On the other hand, bilateral safeguards are against specific countries, particularly countries which India has signed some kind of trade agreement with. This is because bilateral measures are levied on those products whose imports may have increased because those products have a low customs duty rate due to the operation of some kind of trade agreement. So if there's a concession on steel from Japan, then India has a right to levy bilateral measures under the India-Japan agreement. Simple example. As far as the nature of relief is concerned, the relief in global safeguard measures, as we've seen, is essentially a quantitative restriction of some kind or duty on imports. Okay. In bilateral safeguards, the relief is simply the removal of the concessional advantage. So let's go back to the steel from Japan example. If I wanted to enact or activate some kind of bilateral measure on auto parts from Japan, what I would do is I would not put extra duty on auto parts from Japan. I would simply remove the concessional advantage that auto parts from Japan have under the FTA. That's the difference between bilateral and global. So global safeguard, sometimes you see a 25% duty being levied. You'll usually not see that in bilateral safeguard. You'll see that the 10% duty on auto parts or 5% duty on auto parts will get restored instead of a concessional rate. That's the result of a bilateral measure. All right, so now we've differentiated between these two. Let's get a little more detailed into bilateral safeguards. We'll also see how global safeguards are assessed under FTAs, but let's get into that now. So free trade agreements and how they cover global and bilateral measures. So most modern regional or free trade agreements tend to include certain language on global safeguards, and also of late very specific provisions on bilateral safeguards. Recent agreements have evidenced that a lot. Safeguards under India's trade agreements. Now, like I said, many recent agreements tend to cover some kind of language on global safeguards. So what the language, the common theme between that language, although the nuances may vary, is basically to say that your right under the WTO to levy global safeguards is retained. That's essentially what it is. At point number one on your screens, you can see several examples where these trade agreements have used language which affirms these things. Apart from global safeguards, FTAs have now started containing detailed provisions on bilateral safeguard measures. Again, examples are on your screen on point number 2. Bilateral safeguards now also require detailed investigations to take place. So we went through that whole rigmarole of things that we would need to do for global safeguards to be levied. A very similar set of standards also exists for bilateral safeguards, and you would need to accordingly file evidence for those. Some agreements may also require consultation and have unique requirements. We'll get into those. Some agree, so every agreement is subject to negotiation, and therefore, the interesting thing is that no two agreements have the same bilateral safeguard requirement. So depending on the country from which your import is hurting you, you would need to assess the bilateral safeguard measure and the provisions under that agreement, and then see how you can go about countering those imports. Now let's now discuss bilateral safeguard measures in greater detail, since we're on FTAs. Now bilateral safeguard measures can be, the same prerequisites exist largely, okay, as global safeguards. One is an increased imports, second serious injury, but third is something unique you'll see here. The key difference here is the replacement of unforeseen developments with point number 3. In safeguards, you would have, in global safeguards, you might recall I touched upon what are unforeseen developments. But here, unforeseen developments is not a requirement. Instead, the requirement on point number 3 is there, which is, instead of proving that increase in imports was on account of unforeseen developments, in bilateral safeguards, the authority needs to ascertain that the increased imports and subsequent injury were triggered by a reduction or elimination of duties in the FTA. This is important because otherwise any country might say, okay, I'm going to stop your imports. It's important that they prove that the domestic industry of that country getting hurt and the increase in imports can somehow be causally linked to the decrease in the concession rate of or the decrease in the customs duty applicable under the concession rate granted under that particular regional trade or free trade agreement. Now, what are the types of bilateral safeguards? The types of bilateral safeguards basically vary on the basis of the relief granted. Like I said earlier, no two bilateral safeguards in trade agreements are similar. They always have some overlap and they have some differences. So in some cases, it may simply be a suspension of further reduction. All right. So it may not be the case that you restore customs duty back to the original non-reduced or non-concession rate. You just stop concession going further. Second is that, you restore it back, but then you restore it back to what? Do you restore it to the current rate applied to everyone else? Or do you restore it to the rate applicable at the time at which you entered into the agreement? Because those two rates may also vary as policy evolves. So whichever of these two is lower, that is the one that will be applied. The example being India, Korea, that's the one they did. Another example is the India-Afghanistan PTA, preferential tariff agreement, or the APTA, where the agreements only refer to suspension of present concessions and do not specify requirements regarding MFN rate, etc., etc. So there is a lot of variety, and you would really need to assess which country and what product you're talking about. Now let's see how trade agreements frame other provisions on bilateral measures, because there's again variance there also. So the difference in measures can be classified as you can see on your screen. There may be a time limit differentiation. The type of measure or relief that you give may be different. There may be a correlating clause saying that if there is a global safeguard also in play on the same product, then you cannot have a bilateral safeguard. There may be something like that also. So, and then lastly, and very curiously, there may be a compensation mechanism for bilateral safeguards. Let's get, so, continuing the trend from the previous slide, we see that trade agreements can contain, various specific provisions. And let's see some specific examples of these. So one such example is the installation of something called a transition period. The transition period, now this transition period will feature in the agreement. So in this case, we're talking about the India-Korea Comprehensive Economic Partnership Agreement. So the transition period is usually, a number of years which you determine in which that bilateral safeguard can be levied. And only in that period can you levy that bilateral safeguard. For instance, in the CEPA that we're looking at right now on our screens, there's a 10-year transition period, which gets triggered once duties are eliminated on a particular product. Let's go back to auto parts from Japan, or let's say televisions from Korea. If duties on televisions from Korea become zero in 2015, you have a 10-year window from 2015 to 2025 in which you can levy bilateral safeguard measures. Once 2025 is gone, you cannot levy bilateral safeguards anymore. But like most agreements, the India-Korea CEPA recognizes the global safeguard rights also. So you can always levy a global safeguard measure. But post 2025, in this particular example, bilateral safeguard would not be accessible to you. Now, please keep in mind that any concession that India gives varies from product to product. So even under the India-Korea CEPA, for televisions, the duty may be eliminated in 2015. For auto parts, it may be eliminated in 2019. So the 10-year period starts differently for each product under the respective CEPA or agreement. So this is one way in which different agreements have different provisions on bilateral safeguards. Another very interesting example which I mentioned previously was the concept of compensation. Okay, compensation measures are kind of self-explanatory, right? If any party levies, say, a bilateral safeguard measure, the counterparty, or say, so let's say television from Korea. So if India levies some kind of bilateral safeguard measure on televisions from Korea, Korea can go back and ask for some kind of compensation, which reflects the market or trade value of what the bilateral safeguard has cost Korea. There are, again, each agreement may have different things. So under the India-Japan CEPA, you are required to have some kind of a consultation to determine and mutually agree on what is the compensation going to be. If there is no compensation that you can agree upon, then the other party can simply say, I'm going to also levy some kind of duty to compensate myself. So you levy duty on my products, I will levy duty on your products. That is also possible under the India-Japan CEPA. All right. So we've now canvassed global safeguards, bilateral safeguard measures, how they're treated under various trade agreements. Here are some concluding thoughts, and then we can take questions on safeguards and also anti-dumping and anti-subsidy if you have any. I'm sure Parth and Sanjay will be eager to answer. Okay, so final thoughts are as follows. Based on the various examples we just examined, trends indicate a steady move from a less regulated to more regulated comprehensive bilateral systems, such as those under India's CEPAs and other agreements. There is no evidence of bilateral safeguards being used against India, but India's use of these measures against its trade partners has started to see some growth, particularly in 2020, as recently as 2 or 3 months ago. So the first two cases you can see there on your screen, polybutadiene rubber and phthalic anhydride, are May and June cases. So these are very recent developments. India has started taking these tools and using them to protect its industry. There was one more case previously, I think that was in 2019, late 19, on palmolene oil and palm oil, but that ended up getting terminated. Regardless, so this is, there's a growing trend and there's a tool to be exploited. Indian industries would do well to use it now, since transition periods are still alive. Once transition periods go, these opportunities will have faded and we'll have to rely on the anti-dumping safeguards, global safeguards and anti-subsidy. This brings us to the conclusion of our presentation. Thank you for attending, giving us a patient hearing. We'd be happy to take any questions you may have. Thank you.
Thank you, Mr. Amrish. Thank you very much. May I request Dr. Sanjay to take the questions? Mr. Sanjay to take the questions?
Yeah. Would it be possible to address the questions which I already have in the Q&A section? Start.
Sure, sir. Are you able to see the questions in your screen?
Yes, I am able to see all the questions.
I am not able to see for some reason, Vishnu Priya, so I think we'll have to adjust the questions.
Sure.
Okay.
I think, Mr. Sanjay, is it possible for you to direct the questions to the right person based on their...
yeah, I'll do that. Yeah. There is some background noise. Can I request... yeah. So how do we know tariff rates for all the items under FTA? It's very easy to go through these items. They are available on the Ministry of Finance website under the customs notification. So if you go under the CBIC website and look at the customs tariff notifications, under each of the FTAs, there is a list given of all the countries with whom we have an FTA, and accordingly what are the rates agreed. So every year these rates, depending on what we have negotiated with the country, these rates are available on the website, and therefore I would request you to rely upon only the customs notifications, because ultimately that is what is accepted at the port and is the best way to look at that. How do we get to know tariff rates for different products from different countries? Again, like I said, you can look at each country. So India, Korea, India, Japan, India, ASEAN. So that is where all the rates are given. With more problems in economy of individual countries, do we see the countries going back to protectionism in the future? Yes, as we see right now, answer is yes, because in the short term, till we bounce back from COVID, till we bounce back from all the geopolitical situations which we see, fortunately, unfortunately, due to certain leaderships. So until unless we come back from the COVID and some of these elections getting over in other countries, we will see this for some period of time, and that's a backlash of the economy and the backlash which we will have to go for. Is there a regular updated database to check the duty rates? As I answered, yes, the CBIC would be the best. Can we seek relief of anti-dumping duty if duty-free imports are causing inverted duty to domestic producers? Yes, of course, you can go ahead and ask for anti-dumping duties if even if the duty-free imports are causing inverted duties situation for the domestic industry. Of course, the principle is that if you are saying anti-dumping, A, you should be a domestic industry who has the stake to ask for a duty. B, there should be dumping. C, there should be injury. And fourth, the injury being caused to you is plainly from that perspective of imports coming into the country and injuring you. So if you tick mark all these prima facie conditions, answer is yes. What is the current status of CEPA with Korea, which ended a year back? Let me tell you, CEPA, as per my information, is still in force. There are some limitations on bilateral safeguards, but as far as possible, there is no limitation on anti-dumping duty, even if the import duty becomes zero. So you can go ahead and if you have any issues with Korea FTA, go ahead and still use any trade remedial or any other measures under which we have agreed as a relief. And let me tell you strategically, even under the FTA, if there are certain limitations which we may in detail read, because there could be certain limitations and conditions under a product or so, you can surely under the WTO agreement, nothing stops you to go ahead and find your answer, even taking that as an agreement. Whether customs duty concession or exemption is creating dumping margin. No, I don't think, yes, it could be one of the bases, but that can't be the only basis for dumping margin, because like I said, dumping, that's an effect to analyze whether the exporting country is actually dumping the product, because it could so happen that while it is injuring, but there could be no situation of dumping. And customs duty concession and exemption, like I said very early in my presentation, that could be one of the bases, because idea is that to promote trade, and when you see the duty concessions going low, you expect the volumes to go high. Now, it's not only the volumes which cause dumping, but it has to be free and fair pricing, which is more important, and that is something which you got to analyze. What is the future of MEIS? Is there any other scheme likely to substitute? Like we said, the government is already looking at road tax. We've started seeing the effects of road tax on a sector like textile. We also know that currently the DGFT has been collecting a lot of information on each of the sectors to see how can they reimburse the domestic industry and the exporters as far as possible, to see what is the loss in case if the MEIS goes. Answer is when the MEIS, now based on news reports, we keep on hearing that the minister has agreed that because of the COVID, we could only see a year of extension up to 2020, and the effective date for road tax also will be announced soon by the government once the COVID issues are taken care of at the earliest, and the effective date could be given from there. With more problems in the economy of individual countries, do we see countries? Yeah. So those are certain questions which we have already answered based on the Q&A. If there are some more, we would be happy to take them. Otherwise, you have our contacts and email IDs, or through the CII, we would be happy to take your questions and reply back to them, so that ultimately all the clarifications and questions remain answered.
Sure, sir. We will. Are you okay sharing the presentation with the participants? We will circulate it to them.
Yeah, I'll send you the final copy, which you can then circulate.
Okay, sure. So along with that, we'll share the contact details. They
Yes,
will
I
send
will
you.
do that. I will do that.
Okay. Okay, sir. Thank you. Thank you very much, Mr. Sanjay, Mr.
Thank you.
Parthasarathi, and Mr. Ambrish. Thank you for joining, and thank you all the participants. Hope you had a great session. So we'll come back with a lot of sessions like this. Thank you very much.
Thank you so much.
Thank
Have
you,
a
sir.
great
Thank you very
evening and
much.
stay safe. Bye.
Thank you very much.
Thank you. Thank you. Thank you. Bye.
Customers எப்போ ரேட் குறையும்னா நிறைய ஆப்ஷன்ஸ் கொடுக்கும் எல்லா இதுமே லாஜிக் நிறைய ஆப்ஷன்
All the best.
அதான் பரவாயில்ல ஒரு பீஸ் இது வேதா சார்மன் ஆனா பரவாயில்ல இன்னைக்கு அப்படியே வேதா எப்பயுமே வந்துட்டு
Hello.
பேசிக்கா ரொம்ப நல்லவங்க ஃபேமிலி அது
அப்படி இல்ல அவங்க பத்தி தானே குறை பேசுறோம்.
அதுக்காக சொல்லுவோம். இல்ல அவங்க வந்து சும்மா
இல்லங்க அதுலயும் பின்னாடி பேக்ல ரீசன் இல்ல அதுல அதான் ஏதோ ரீசன் அவங்கள வந்து நிறைய பண்ணி அவங்கள யாருமே அப்ரிஷியேட் பண்ண மாட்டேங்கிறாங்க அந்த இதனால. ஆமா
நான் சொல்லிட்டேன் எனக்கு ஸ்பான்சர்ஷிப் புடிச்சு போகும் அது ரொம்ப குஷி ஆயிடுச்சு. அதான் நான் சொன்னேன் ஏன்னா நம்மளோட இது காம்படிஷன் கம்மியா ஒர்க் ஆகுது நம்ம ஒர்க் பண்ணலாம் ஸ்டார்டிங் கமிட்டிக்கு ஒண்ணுமே கான்டாக்டே இல்ல அவங்க கிட்ட